It is a great pleasure to be here with you.
Fifth edition of the FIFA Football Law Annual Review in Mexico City. It is great to have so many participants here with us today. And it's great to see that so many are joining us here in the event. A special welcome to the President of the Mexican Football Federation and its GS. All good afternoon or good evening to everyone who's following us on the live stream. As usual, you can follow us in English, Spanish, and French. All material that will be here today with us and tomorrow, as well as the recordings, will be available on FIFA.com, same as all the previous editions. Day one is fully dedicated to the FIFA legal framework of 2022 and an outlook to 2023. You will get some presentations about the FIFA clearinghouse, the FIFA agent regulations, the most recent transfer reforms, the FIFA disciplinary and ethic code, as well as CAS and football in 2022. Tomorrow, on day two, we will focus on concrete discussions about aspects of CAS. For the welcome, we wanted to have with us here today the FIFA president, Gianni Infantino, and that's why he's not able to be with us here in Mexico City. However, he's sending us a video message which we will now have here on the screen, and I hope that you enjoy the message of the FIFA president. Thank you.
Dear ladies, indeed, Canada and the United States quite a lot in the coming months and years. But I apologize that, of course, I cannot be with you there today. Since 2019, FIFA has been football's regulatory framework on its case law and, of course, the main decisions of its judicial bodies. Continually improve and unite the world. Football is the most democratic sport of all, so it is our role to bring everyone together through events such as these. In doing so, we appreciate this dialogue and are enriched by different perspectives that you bring. We can also demonstrate considerable successes, such as the work on the FIFA clearinghouse, which was launched last November, the implementation of the football agent regulations, an integral part of my vision and of FIFA's ongoing commitment to promoting financial transparency and integrity and ensuring that training rewards, so the training compensation and the solidarity contributions, are effectively paid to the clubs that deserve them. The football agent regulation means that we will have new rules that will guarantee minimum professional and ethical standards for football agents all over the world, including also a mandatory licensing system. And last but not least, the Football Tribunal consolidates the previous FIFA decision-making bodies under one single umbrella body. So in a nutshell, we are creating a fairer and more transparent legal framework for football, which is not based on individual interest, but on solidarity and equity. You will discuss all of this and more in the upcoming sessions, as well as the roundtables that come with external experts. And if you want to know more about FIFA's legal and compliance division and the recent activities of Emilio Garcia and his team, the only thing you need is time. Time to read the multiple reports with the aim of giving knowledge to the football community as a whole. Transparency in football law, as with all areas of our administration, matters. It matters to the integrity of our sport. It matters to the sustainability of our sport. And it is at the heart of the FIFA that we serve today. So thank you very much for your participation and for your support, and obviously I wish you an excellent session to come and every success. All the best, bye-bye, and see you all soon.
Now, after the opening via video of the FIFA president, I would like to invite to the stage the president of the Federación Mexicana de Fútbol, John de Luisa, our host here in Mexico City. Thank you for having us with us today.
Muchas gracias.
Thank you very much, Maya. Good morning. Good morning, everyone. Welcome to Mexico. On behalf of the Mexican Football Association, we are delighted and honored that FIFA has chosen Mexico City and our country, Mexico, to celebrate these sessions. As Mr. Infantino was saying, we are looking for transparency for our organization. We're looking for FIFA transparency, its processes, its governance, but mainly we want to create a rich experience through a very fundamental dialogue, which is fundamental for our industry in the football world. Thank you to Mr. Infantino for being here through his video message. Welcome to FIFA. They are great friends of us. Emilio, Yair, CONCACAF, dear Philippe, dear Mexican friends, dear friends of the FMF. Thank you for being with us. Welcome to FIFA. Welcome to all the confederations who are represented here. Welcome to all the member associations, the leagues, the clubs, the representatives, and everyone who is with us here in person in Mexico. And also welcome to everyone following us through the live streaming all over the world. Our industry, the football industry, is growing, and it's also undergoing a transformation every year. For this reason, events like the one we are celebrating today are very important because they allow us to be up to date about the regulations on our industry, but they also allow us to have a very healthy debate for the sake of our industry. I'm deeply grateful to Maya and the event organizers, and I wish all of you, all the participants, to have very fruitful sessions. So please feel our most warm welcome to Mexico and to the FLAR event. Thank you very much.
Muchas gracias, John. Es un gusto.
Thank you very much, John. It's a pleasure to be here.
FIFA Chief Legal and Compliance Officer, Emilio Garcia Silvero, the founder of FLAR, to give us an overview of 2022 and an outlook of the FIFA legal framework of 2023. Thank you, Emilio.
Thank you very much, Maya. Good morning to all of the participants who are in Mexico City and to all those who follow us in the same time zone. Good afternoon or good evening to those who follow us live on FIFA.com in all the time zones of the world. Welcome to the FIFA Football Law Annual Review 2023. It is a great pleasure to be able to present this annual FIFA activity from Ciudad de Mexico. As the President has highlighted a few minutes ago, since 2019, the FIFA Football Law Annual Review is an official activity that we organize annually and whose objective is to share with the entire legal community in the world of football the main regulatory changes, decisions, and issues of interest that emanate from FIFA and the Court of Arbitration for Sport. As I was saying today, we are pleased to be in Ciudad de Mexico, in the territory of one of the 6 FIFA confederations, CONCACAF. Mexico is a pure football country. We are in the city that will soon host a FIFA World Cup for the 3rd time in 100 years. A few kilometers from where we are today, we can visit the legendary Estadio Azteca, the host of the FIFA World Cup in 1970 with the great Pelé, the FIFA World Cup final 1986 with the unique Diego Armando Maradona, and for sure some incredible matches of the upcoming FIFA World Cup 2026, which will be hosted in the CONCACAF region by Mexico, Canada, and the United States of America. In this part of the world, and particularly in this lovely and amazing country that Mexico is, Spanish is the official language. And in honor to our colleagues and hosts here, I will continue the presentation, if I may, in Spanish. I will switch now to Spanish for the next few minutes. Okay.
Well, good morning, everyone, again. And as you know, the first speech for about 15 minutes is based on the analysis of what we have achieved in 2022 regarding the legal framework at FIFA and compliance, and also regarding some aspects that we are working on for 2023. I think that the most interesting talks will be the ones delivered by my colleagues, for example, the changes in the new regulations of agents, the FIFA clearinghouse, disciplinary matters, also CAS jurisprudence, and tomorrow we will have even more practical topics. So I would like to briefly touch upon the most relevant aspects of 2022, and I would like to share this knowledge with you and focus on some of the projects that we're working on for 2023. In 2022, we've had quite some new things. I wouldn't like to say as usual, but it is true that there are two projects that have finally seen the light. One of them is the FIFA Football Agent Regulations. After a long period of hard work, consultations with the different stakeholders, the confederations, the MAs, lawyers, several agent associations all over the world, we have been able to approve these regulations in the FIFA Council celebrated in Doha in December 2022. And these regulations are partially in effect, especially regarding those that have to do with the licensing system, and they will go into full effect in 2023. Actually, Luis Villas-Boas will talk about this topic with more detail. 2022 was also the year that finally, and I would like to say thank God, we finally launched the FIFA Clearinghouse project. We've been working on it for a long time, several years. We've had many colleagues involved. There's been a lot of work put into it, and it's a very complex project from a financial perspective. It's also very complex from an administrative point of view, more than what we had originally thought. And, we had discussed with our colleagues how to solve the solidarity contributions and training compensations and so on. So this was a nice idea 4 years ago. It was, in paper, easy to implement. But the reality is that when we try to make this a reality, and we have to think of the different things that we need to keep in mind, like getting a license, for example, in European countries, well, it hasn't been easy. But we have had throughout the support of Mr. Infantino, the FIFA president, and we have been able to sign all the contracts with banks, getting the license, and we have been able to put into effect the clearinghouse starting in November 2022. We have also been able to approve the regulations, and we have been able to start with the first EPPs, and Cesar Chaparro, actually, who is the director of the clearinghouse department, will touch upon all these details with more detail. Also, fortunately or unfortunately, we have changes in our regulations of the RSTP. This is something that happens every year. We go through long negotiation processes with FIFPro, the agents, the clubs, for the reform of the transfer system, and I will touch upon that later on. But this year, we have had several reforms. We have had reforms on loans that had been approved previously to COVID, but it has gone into effect afterwards at club's request. So the new regulation for loans have come into effect this year. And there have been also two very important reform packages with more flexible regulations regarding situations where players, because of humanitarian reasons, have to move from one country to another. So the new law is more flexible. The new regulation uses common sense so that children can keep playing football in other jurisdictions without having to go through very strong scrutiny from FIFA. There's also new regulations for private academies for minor players. And finally, there's something that we found very important, which is to have some basic regulations regarding trials. The CAS had asked us to consider that, and we had some cases where we had considered these aspects. But now, the new regulations about trials for players will give more certainty at a legal level for minor levels, especially for minor players especially, and they have been included into the RSTP. 2022 was also the year that we saw the invasion of Ukraine on hands of Russia. This is a war that we have felt very close to us in Europe, and we have been affected not only at economic level, but mostly at a human level. And for that reason, we implemented special regulations regarding the registration of player rights in this area. That's the well-known Annex 7, which is still in effect because of the situation with Ukraine and Russia. And of course, we will reconsider that for the next transfer window in summer in Europe that will start in July. Also in 2022, beginning of 2023, although it was approved in 2022, has allowed us to see new versions of the FIFA Disciplinary Code and the FIFA Ethics Code. My colleague Carlos Schneider, who is the Director of Judicial Bodies at FIFA, will touch upon that in more detail, and I think we will also share a very detailed document apart from the circular letter that explains all the changes. And all these reforms of the code are part of our perspective of working with institutions outside of the football world and the football family. We also work a lot with IAF, and I would like to acknowledge the people from IAF, Patricia, and other colleagues who were at the meetings we had in Zurich. And I would like to thank them because they brought very good ideas to the table, very interesting proposals, and they have been reflected in this reform of the FIFA Disciplinary Code and the FIFA Ethics Code. Carlos will refer to that later on. The reforms aim to protect victims in very specific situations, but all the proposals from IAF have been very welcome, and most of them incorporated in these renewed versions of the Disciplinary Code and the Ethics Code, and we hope that we can keep working with them so that we can work on amendments and updates on our regulations in order to improve. 2022 was also the year when we renewed our agreement with the ICAS and with CAS. As you know, every 4 years, ever since 2003, when FIFA renewed its statute, FIFA has been signing 4-year-long agreements where we establish several financial conditions of what FIFA brings to the ICAS so that all the proceedings are not more expensive than what they should be. This agreement, 2023-2027, is a turning point of our work with CAS because of 3 reasons. First of all, for the first time, the ICAS, which is the governing body of the CAS, something similar of the FIFA Council, but in CAS, will have 4 representatives of the football world. This is the first time in history that happens. There will be 4 representatives representing FIFA, the leagues, the clubs, and also FIFPro, the Worldwide Football Union. And this is a big step forward that will allow us to move on in very important aspects. Some days ago, actually, we published our report on CAS and football, and 78% of the proceedings with CAS have to do with football. That makes it clear that football is a basic part of CAS activity. And it is our duty and our responsibility that proceedings work well, that CAS is a very well-governed organization and a very efficient one. And I always say this, from FIFA and from CAS, these are not perfect institutions, but CAS is the right institution to settle and solve our disputes between players and FIFA, confederations, teams, and so on. For this reason, it is our responsibility and our duty to make CAS a better organization every time. And I think that by having these 4 representatives sitting at the ICAS, we will have a good opportunity to work and see fundamental improvements in this very relevant institution for the world of sport and especially for football. Within this new agreement, there have been some new amendments for the edition that went into effect November 2022. Several of the proposals were proposed by FIFA to improve the proceedings. And finally, within this framework, we have agreed for the first time to have to set up an aid fund for players, both male and female, and also for clubs. It's a football legal aid fund for those who want to challenge FIFA's decisions or the Confederation's decisions and bring them to CAS. It's the first time that someone puts money on the table so that those who do not agree with FIFA decisions can challenge them and move forward. This is our responsibility. For the first year, I think we agreed to put on $250,000, and the idea is to put that money into this aid fund for max fixing or disciplinary infraction matters. This fund will be managed by ICAS, and we will have annual reports that will be shared with FIFA. And the aim is that this fund can fund legal expenses that players or clubs have in these proceedings. In the framework of this Football Legal Aid Fund, we also agreed on some more specific aspects with CAS. There will always be a sole arbitrator. We won't have 3 arbitrators, so this is something new. This sole arbitrator panel won't be getting any funds for administering these cases. They will do this pro bono, and actually CAS will not receive the famous 1,000 Swiss francs. So 100% of the money that we are investing into this fund will be for players and for those who can benefit out of this Football Legal Aid Fund in CAS. The guidelines for all this proceeding and the fund are published in the CAS website and also in the FIFA website. In 2022, we also published many different materials, and actually Mr. Infantino referred to that. We published several reports on our ongoing activity. And apart from all the anti-doping football tribunal reports, I would like to focus on 2 very important reports. One is the report that analyzes the reform of the transfer system from 2017 to 2022. This report shows all the progress and modifications that we have worked on for the past 4 or 5 years, together with the ECA, with the Football Union, FIFPro, with the confederations. All the work that we have undercarried is reflected there. It's very well structured. It's a very easy to read report. And if you haven't downloaded it yet, you can do so at our website. And then you will have an overview of all the work we have carried and the vision for the next year. In any case, we also have the CAS and Football Annual Report. And I would like to apologize in advance. We always work on these materials in just one language, in English. And that was something that we didn't really like that much when I worked at the Spanish Football Federation. We always said, why are they done in English and not in Spanish? I guess French speakers one are the same, right? But once you get into the structure of creating these reports, it is hard to create them in the 3 official languages, and it makes the whole process much longer. So I would like to apologize in advance, because it goes against my own principles, actually. But it is what it is, and the reports are available in English right now. I think that most of us, we speak maybe a bad English, but it is good enough to understand what we publish. So this CAS and Football Annual Report will be an annual report. It will be published every year in January or February, and it will compile all the FIFA activity at CAS and also some statistics on how important football is and some decisions against national associations and confederations, and also show some numbers at a world level. Also, when we talk about what we did at FIFA, it will include also the arbitrators we appoint in our proceedings. We have been accused of always using the same arbitrators. Well, it is easy to have several different arbitrators when you have only 5 appeals per year. But if you have more than 190, Cesar, and correct me if I'm wrong, it is easier to repeat the same arbitrators that are appointed for those cases. So for this reason, we publish a list of the arbitrators that we use in our proceedings. And it's not that we prefer to use a certain arbitrator. We just work with many, and we will keep doing so. And we hope that CAS does that also in the future, and they publish what arbitrators are appointed for each proceeding, because transparency is very important. And this is everything about 2022. We have worked on many fundamental aspects, thank you to the stakeholders and several associations. So what's in the pipeline for 2023? Well, when we talk about the registration period reforms and the transfer reform, there's a reform package regarding transfer windows, and also we're trying to give more possibilities for those players that do not have a club. And that will be seen in detail on March 14. So over the next 15 days, there will be some relevant modification on the transfer system regulation, so that we have wider registration periods, and also to make it easier to players that are out of club. Also, for the past 2-3 years, we have been working on rethinking the training reward system for training compensation and solidarity contribution. I'm a very small part of FIFA, but I'm not a huge fan of training compensations, maybe because I'm closer to players, right, than the global industry per se. I think that after 20 years, the training compensations and the solidarity mechanism need to change. We need to find the right formula so that everyone is happy. So if you have any ideas, they are more than welcome, from the most absurd to the most clever ones. They are all useful for us. And actually, these kind of events help us because we can gather ideas from several colleagues. My view for 2023 is to work on this regard. The market has changed in many aspects, in the number of transfers, in the money out in the market. And for this reason, the system that was originally thought of in 2001 now needs to be rethought. There's also something else, the very well-known Article 17 of the RSTP, and that may be trickier. Players, clubs, that's something that we have on the table, and we want to tackle upon that on 2023. And finally, we have a package of measures for 2023 that we're working on and analyzing. We would like to bring them to the table and bring them to the FIFA Council. They are still not very well defined, but if I can say something about them, is that we would like to consider the multi-club ownership situation. We would like to see if we need to work on that regard. We want to analyze that and maybe see if we need some new dispositions about that, something we need to work in 2023. And we have John Sol and some other members will consider whether we need to tackle upon that topic. We also want to take a 2.0 step forward for those regulations that have to do with minimal labor conditions for female players. As you know, in 2020, we approved a first package of measures that are nationally binding. We know they have not been very successful in the 211 MAs. It's a work in progress, but we would like to open a new debate in 2023 to see whether those regulations that were approved 2-3 years ago have worked or not, and also to discuss what aspects we would like to reform and where we would like to move forward. So we will see some measures that will be discussed in next meetings. It's the year of a World Cup, of a female World Cup in New Zealand and Australia this summer, and we think it's the right moment to take one step further with anything that has to do with the personal situation of female players in football. Finally, last year, we introduced the legal portal. This is a tool that allows us to be connected in several legal proceedings with the disciplinary commission, the ethics committee, and this legal portal will be mandatory as from 1st of May 2023. We have been on a trial period for a year. We have gathered several queries from several colleagues, and we think that from a technological perspective, the tool is ready and is also ready to be mandatory. So again, as from May 2023, all relations of FIFA through through the Football Tribunal or through the Ethics Committee will be managed through the legal portal, and that will bring more stability to FIFA and FIFA administration. It will be able to solve some problems that we have seen as of today. We are really willing to start working through the legal portal so that we don't have to go through emails, and of course not with fax, that's ancient history, but the email will not be valid anymore for proceedings with the Football Tribunal, the Ethics Committee, and the Disciplinary Committee. So two new things also for 2023. In the bag that you got today, there's an edition of the commentary on the FIFA RSTP. And as we promised, this is something that we would like to do every 2 years. So in November 2023, we will be able to have a new version of the commentary on the regulations of the status and transfers of players. Young, Erika, and the team are working on this new updated commentary. They are working on the first draft. James has also been part of this drafting process. I think that we are up to speed, and I can say that in November 2023, the new commentary edition will be available. I think this is a very useful resource for those who work in the industry. And finally, and Luis Villas-Boas will touch upon that as well, we have also the agent chamber of the FIFA Football Tribunal. That's in the pipeline. As Mr. Infantino said, the Football Tribunal actually includes the Dispute Resolution Chamber, the Player Statute Committee, and then there's a third pillar that will go into effect with the Agents Chamber that will be made up of representatives of several football associations, confederations, agent organizations. We have created a working group so that we can work with football agents, and we are hoping that we can go live and start working with the Agent Chamber in October 2023, managing the first cases. Luis will talk about the competence of the Agent Chamber, which is somehow restrictive or restricted to international dimension cases. But in any case, we hope that it will be very useful for the football sector, and especially for clubs and agents that have problems with their disputes. And now I'm coming to the end of my presentation, the most important one, the part where I give thanks. First of all, John, the president of the Mexican Football Federation, and Íñigo, the Secretary General, thank you so much for bringing us to Mexico. This is a great country. Thank you for giving us the opportunity of being here. Thank you for your help, for making things so easy for us to celebrate the 5th floor edition here in Mexico. We all know that John de Luisa has said he's not going to run for re-election in 2023. And personally, I would like to say that this is a very sad piece of news for Mexican football and for those of us working at FIFA. John is member of the FIFA Council since last year. He actually brings good vibes to the group. He is willing to work. He has projects in mind. He is a person really easy to work with, you know. Sometimes it's not easy to work with people, but John is one of these persons, just as Sol, who are members of the FIFA Council, and they're normal people. They work with the administration, they bring ideas to the table, they are willing to do things, and knowing that you are not going to run for the president re-election, well, what can I say? For me and my FIFA colleagues, we think this is very sad. I think that the Mexican Association is missing a very good president, but of course the FIFA Council is also counting on a very fruitful new member. So this is not a goodbye, it's just see you soon. But it is true that we will miss you at a local level. However, of course, we count on you at the FIFA Council. And thank you so much for all your help, Inigo. Also, thank you to your team, and good luck with everything, and for your future professional life, and for your next daughter, who will be born very soon. Thank you as well to CONCACAF Felipe, Victor, who has just been recently re-elected. It is always very easy to work with CONCACAF. I said it just last year at with the AFA, with the CONMEBOL. The relation with CONCACAF is excellent. They are doing a great job with the new America Cup between CONMEBOL and CONCACAF. I'm not going to miss it for sure. And Philip and the whole CONCACAF team, thank you so much. And now I'm ending my presentation. Thank you to all of you. You are coming from all the world, from Japan to South Africa, from Europe to South America. And this is a great opportunity to meet, to enjoy the academic aspect of our world, but also the non-academic one, which is also important in life. So thank you so much for those who make the effort to be part of this FAR event. And lastly, thank you so much to my team, to the FIFA team, and to all my colleagues. Many times, I'm the visible face of this event, but there are many people working on this, on all the reforms, all the documents, all the reports. This is not just a one-person work. There are many people involved and many hours of work, and it happens the same with the FLAR event. Sebastian, Teo, Maya, they invest many hours to put all this together, to put the streaming together, to set up the stage, and this is only possible when you have a team willing to work. I've always said this. We are not perfect. We make mistakes. FIFA is not a perfect organization, but I can assure you that people who work here, and I also saw my colleague Jair, who works from a more development perspective, we try to do things with the idea of serving clubs, people, the fans, because finally we are here to help. So thank you so much to the FIFA team, to all the legal and compliance team who day by day work very hard so that we can modify the transfer system, so that we can bring data to the table, so that we can organize several academic activities in all the world. And this is only possible because we are willing to put in the work. That's not something that is paid with Swiss francs or with plane trips or hotels, you know. After 6 months, you get tired of that. So this only works when people are willing to invest that time. I will leave it here. I hope I haven't taken up more time than necessary. I think I'm on time. But in any case, thank you so much for the attention. I hope that you enjoy today's session. Tomorrow's session will have very interesting speakers. Our speakers will be delighted to have questions coming from the public and also criticism. We're also interested in that, you know. Many people come and knock our door and say, good job, keep on going. That's fine, but we're more interested in receiving criticisms, you know. Of course, if we're doing a good job, it's nice to hear that, but when we hear people saying that maybe we're not doing that well, that helps us to move forward. So I invite all of you to do so, to share questions with the speakers. On my side, this is it. I have the easy part, but my colleagues and the guest speakers that we have brought to tomorrow's session have a lot to say. So again, thank you so much to our hosts. John, thank you so much. Inigo, Philippe, CONCACAF, thank you so, so much. And I hope you have a great day. Maya, you have the floor again.
Thank you.
Muchas gracias.
Thank you very much. We will give our Spanish interpreters a break and resume in English.
Emilio several times now in his presentation, one of the main aspects is obviously the clearinghouse. Following the approval of the regulations by the FIFA Council in October last year, the FIFA clearinghouse began its operation in November. That's why we have our next speaker, which I would like to invite to the stage, Cesar Chaparro, the FIFA head of clearinghouse, who will give you a presentation about the regulation and the practical cases that they have had since the coming into operations. So Cesar, thank you very much, and not sure if you're going to speak English or Spanish, but whatever you would like. Thank you, Cesar.
Muchas gracias, Maya, y muchas gracias.
Thank you very much, Maya, and thank you to the Mexican Football Association, Inigo, John, and of course, thank you to the CONCACAF for helping us organize this event. And thank you all for attending and participating actively.
Thank and congratulate everyone who has made this idea or this dream of a clearinghouse that was started to be discussed some years ago to make it become a reality. With the risk of being unfair with some people that I will not have the time to name, I would like to mention, of course, the vision and leadership of Emilio, of course, Jan Kleiner, James Kitchen also, and Conrado Plano, who was my predecessor as head of the clearinghouse department, and of course, most importantly, to my fantastic team in Zurich and also now in Paris as well, without whom this would not be possible. Today, my intention is divided in three main points, I would say. The first one has to do a reminder to everyone on what is the main aim or idea behind the clearinghouse and where do we stand right now in accomplishing those achievements. The second point has to do with the FIFA clearinghouse regulations, which I promise is not a boring regulation. It's simply the definition of the process of the FIFA clearinghouse, the how it is working in a practical sense. And lastly, but not least, and this is a new part for all of you, for sure, it's a little bit of a photograph of the performance of the system in these first 3.5 months of operation. It's an overview of statistics, but also of practical examples. It's about how many cases we have, which is their status, what are the main challenges we are facing, and what are the lessons learned. First of all, and mainly for those of you who came last year, I have the good news to say that there are a lot of important updates, as it has said before. Here you have a summary of the most important ones. The first one, of course, is that in September, as Emilio mentioned, we finally obtained the license as a payment institution in Paris by the French regulators. That was September 2022. 1 month after that, the regulations of the FIFA clearinghouse were approved by the Council in October. And also, less than 1 month after that, in November 16 of 2022, the clearinghouse started to operate, enter into force. And what does it mean, the entering into force? Because some of you have asked me about that. Well, as those of you who are practitioners know already, it means two things. It means that all the transfers or registrations that happen before the deadline, before the cut-off date, before November of 2022 will go still through the old systems. However, all the transfers, international transfers, domestic transfers, first professional registrations happening from that moment onwards are already covered by the new FIFA clearinghouse system. The next point is that due to that, of course, we are also happy to announce that the system is working very well. We have already more than 4,000 EPPs, 4,000 players whose history is going through the system in different status, different levels. And some of the first EPPs or allocation statement determinations have been already sent to the parties and also to the clearinghouse entity in Paris for further processing of the payments. As most of you know, because you have been part of those, there has been a lot of communication and education being done during the past year. We have carried out a number of webinars with all member associations, with clubs, with the main stakeholders, etc. We have also launched our website, which includes explanatory notes to the regulations, frequent asked questions, a calculator, videos, and of course a help desk that is used massively by clubs and member associations to ask and share their doubts and questions. So all this will be discussed today, but not so fast. I think it's always good to put that into context and to frame it within the broader FIFA strategy. You have seen this a lot. This is the vision of FIFA for 2020-2023, with the 11 goals, the first of which is the modernization of the football regulatory framework. Within that, if we even zoom it a little bit more, it's the whole reform of the transfer system that Emilio has discussed, with the three main waves, or packages, as we call, of reform, which include areas as important as agents, loans, etc., that will be discussed later on. But here in this first part, we are going to focus, of course, in the first reform package, which includes the FIFA clearinghouse. Indeed, it was in October 2018 when the FIFA Council approved the package that was proposed by the Stakeholders Committee. And in this case, it included two main aspects. The first one is the creation of a clearinghouse, of an entity, intermediary for processing the payments between clubs and avoid fraudulent conduct in the world of football. And the second one, very important, the mandatory introduction by all MAs of two systems, two electronic systems. The first one, the player registration system, and the second one, the domestic transfer system, that together with the currently existent TMS will give rise to the whole scenarios covered by the clearinghouse. The project was taking shape in the months and years afterwards, with the main objective, and this can be used probably as a definition of the clearinghouse, to centralize, process, and automate the payments between clubs. It is worth mentioning that we have started with the training rewards, with the intention in the future to possibly expand to other type of fees in the transfer world, for example, the agent fees or the transfer fees themselves. It is good to start with the solidarity and the training compensation because of the reasons laid out by the President and by Emilio of promoting solidarity between grassroots football and elite football and to cover that gap that is existently there. And this is precisely one of the two reasons why we do this. You have seen this graph already in the past, but it's worth repeating that. The first one is precisely to cover that existing gap between the training rewards paid and the training rewards due. There are many reasons for that. We don't know all of them, but of course some of them can be the lack of knowledge of training clubs, lack of knowledge that there has been a transfer in which they have certain entitlements, lack of knowledge of the system of claims, lack of resources, possibly, of carrying out those sometimes lengthy processes, and also the impossibility or the not action in uploading and declaring those payments within TMS. So, as you will see, we are shifting towards that claim system, towards the automatic entitlement. And the second one has to do with, of course, the promotion of financial integrity and transparency, as the President said, for the first time in such a systematic way in football, by conducting due diligence of all the clubs before those payments are actually processed. Those two objectives, again, you know them, are very important to remember because our success will be always measured and discussed and monitored under the prisma of these two objectives. Within that, of course, those objectives have been praised by many stakeholders and also, the European Parliament, Greco in a number of reports, and a lot of other parties. The way in which, this is a summary of the way in which we have tried to tackle some of these issues that I mentioned earlier. So this is a summary of the differences between the old system, the old claim system, and the current new electronic player passport and clearinghouse system. The first difference is that, as you know, in the old system, clubs needed to become aware that there was a transfer, while now the system will identify that automatically. The second difference is that there was a claim to lodge in the time frame of 2 years, or 2 years and 30 days to be more precise. Well, now the system will automatically, from the trigger, will automatically execute the whole process immediately, and probably in 2-3 months the case will be solved. The third difference, which is important, it's because this is an automatic system. In the case of Solidarity, it will be triggered by the uploading of the proof of payment of the clubs, and I will expand a little bit later, while in the old system it was simply from the moment of the installments that were declared. The next 2 points are relatively similar, because both cases will still be dealt with by the FIFA General Secretariat, and the cases of legal or factual complexity will be sent to the Dispute Resolution Chamber, the DRC. But the last one is, again, a major difference, which is that we are moving from a system of club-to-club payments to a system in which the payments are centralized and processed through the FIFA clearinghouse. FIFA could have stayed in the other part only the spectrum of the electronic player passport and deciding how much money is due from this club to the other one, but decided consciously to go further and also process the payments with the consequent due diligence through the independent and regulated entity. So those are the main difference as an introduction of the old and the current system. So I will move now to the second part of the presentation, which is the description of the process, how it works, and I promise that I will mention the updates from last year in the final regulatory process, but also some of the practical issues that arise from the process itself. The legal bases are not new for all of you, so training compensation and solidarity mechanisms in the RSTP. And here's the description of the main articles of the FIFA clearinghouse regulations that I will describe in further detail. In terms of the process, let me be helped by an introductory video that will show the main steps in which the FIFA clearinghouse process is divided.
In the last 2 decades, the FIFA regulations on the status and transfer of players have played a key role in the training and development of players. However, there has been a growing concern over the payment of training rewards, with a growing gap between the payments due and actually paid. With the creation of the FIFA clearinghouse, FIFA will improve this process by closing this gap while promoting integrity and financial transparency in payments. How will this be achieved? Member associations and clubs are an integral part of this change. Clubs must ensure that all their players are properly registered with their member associations from the age of 12. The member associations must have integrated their electronic domestic systems with FIFA platforms. Having up-to-date information on the career of the player will facilitate the correct calculation of training rewards. When a player is transferred or first registered as a professional, TMS will automatically query the member association's system for registration data to include in the electronic player passport, or EPP, of the player. Parties will be able to provide additional information, and the FIFA administration will determine the final version of the EPP. This final version will be the basis for the allocation statement, which will be shared with the FIFA clearinghouse for processing of the payments. The FIFA Clearinghouse, or FCH, is a regulated financial institution established in France that will process payments between clubs. How? After the allocation statement is received, the FCH will perform a compliance assessment on all of the clubs involved in training rewards to make sure that international financial regulations are respected. After the clubs have passed the compliance assessment, the new club will be requested to pay the relevant amount. Finally, once the FCH has received the full amount, it will distribute the rewards to the pertinent training clubs. Multiple stakeholders have praised the initiative of a clearinghouse. This process will bring solidarity to the football landscape and ensure that training clubs that develop young football players around the world get their fair share within FIFA's main goal of making football truly global.
Okay, what I will do now in the next few minutes would be to go a little bit more in depth into those 3 steps that you saw in the video. The first of which is the declaration of the training rewards trigger. In that regard, it's important to mention something that you, of course, know very well mainly from member associations and clubs, which is the basic requirements to make the system work. The first one, I mean, there are 4 main requirements. The first one is ensure that, of course, everyone uses TMS for international transfers. The number 2 and 3 were, as I mentioned earlier, the implementation of electronic systems at the domestic level, which is the player registration and the domestic transfer system. And the 4th one is that they are connected to FIFA Connect ID. So this is how the system is working. Of course, in the implementations of electronic systems, member associations can choose between using their own systems, third parties, like for example Comet, or the ones provided by FIFA, which are FIFA Connect platform and DTMS or domestic TMS. You will wonder, why is this prerequisite so important? So mainly for 2 main steps that happen also in time almost immediately, almost simultaneously. The first one is that what you showed when you saw in the previous graph is basically the way in which the triggers will be communicated automatically. So whenever there is an international transfer, a domestic transfer with fees, or a first pro registration, those will be communicated automatically through those systems. And the second one, almost immediate, as I mentioned, is that at that particular moment, the rest of the member associations, the rest of the 210 member associations will be asked automatically by the system if they have any registration information for that particular player with that particular ID. Okay, so as you can see in this graph, there has been an international transfer communicated, and the system automatically has asked all the member associations, some of which have provided provisionary registration information of the player. So that is the first part, and there is already a provisional EPP, electronic player passport, that provides a consolidated and unique view of the player. The second step has to do with the review process. Because the information, mainly in the early steps of the clearinghouse, is not perfect from the automatic first part, there is a process of review in which relevant parties can complete and edit and nuance that or challenge that electronic player passport. And that review process is divided also in 4 main phases. The first one is the inspection phase, so the provisional electronic player passport is put in the system for review of all MAs and all clubs in the world for 10 days, for them to claim, to raise their hands and say, look, I'm not provisionally here, but I think I have the right to claim for the rights of that particular player. So lifting their hands and requesting to be part of the process. The second part has to do with the review process. And the review process is where member associations and clubs can provide relevant information to complete that player passport. The third one is the validation by our team, by the FIFA General Secretariat, of everything that was uploaded in the review phases with, of course, the possibility to go back and forth with the parties in order to clarify some of the information that was not absolutely clear, and also additional documentation that may be needed. And the last phase is, of course, the finalization of the EPP, which is the determination by FIFA of the history of the player, how much money is due from Club A to Clubs B and C, which are summarized again in the EPP and what we call the allocation statement, which can be challenged to CAS in the period of 21 days. So this is the process of review. And this is how it looks also in TMS. So in the first part, in the provisional EPP, is where the MAs can request involvement, or a club can tell their MAs to request involvement. So this is how it looks. Then we move to the second review phase. And here is where the member associations can amend, can add, or can remove registration information of the player. I mean, they can amend items as important as the dates of the registration, the training category of the clubs, the status of the players, the type of registration, if it's a loan or is a permanent transfer, etc., etc. So this is, again, how it looks. And, well, I have seen here today many of the colleagues that belong to member associations that have already discussed how the system is working for them, and they are, of course, very familiar with this screenshot. Then in this review phase, also clubs can do things. For example, it's very common that they upload waivers, right? So they can upload in the line of the player passport corresponding to the training club, they can upload a waiver. But of course, when we see that waiver, we have to give also the possibility to that training club to challenge the waiver. So here is how it looks in the case in which the waiver is challenged by the training club. The same with contract offers. The third phase, the validation by our team. This is, again, how it looks. It's very important for all of you to know that there is this messaging tool. So basically, our team will communicate with relevant parties through the messaging tool to clarify information or to ask for additional one. In situations of legal or factual complexity, as I mentioned, those cases will be sent to the DRC for further processing. It is worth mentioning also that in this phase of validation, there is a lot of back and forth with the review and validation, because sometimes something that has been brought up in review, you validate, but you have to come back to, let's say, a second review in which the certain parties are allowed to contest the information that was uploaded in review. And finally, as I mentioned, the EPP and allocation statement. When everything is confirmed, it will be, the EPP decision will be issued. In terms of the allocation statement, it's important to note that in the cases of training compensation, the allocation statement is issued immediately after the EPP is final. However, in the cases of solidarity contribution, is very linked to the upload of the proof of payment, which is basically the 5% of which will be triggered the solidarity contribution. So this is a very important point that we are working with the main stakeholders. So when the allocation statement contains the training clubs, their contact details, and all relevant information that will be sent not only to the parties, of course, but also to the clearinghouse in Paris for further processing of the payments. Okay, so once we have this player passport, the history of the player, the allocation statement with the associated amounts, this is the end of the second step that you saw in the video, and moves us to the third one, which is the final one, which is the processing of the payments by the FIFA clearinghouse established in Paris. And here again, quite procedural. The first step is, of course, as I mentioned, the communication of that allocation statement from FIFA to the FIFA clearinghouse. Afterwards, there is the compliance assessment, compliance due diligence of all parties involved. And in case it is accepted or positive, there will be the payment from the new club to the entity, which is again the intermediary. Fourth, from the entity to the training clubs. And last but not least, of course, the fifth one, which is the reporting of all the information from FIFA clearinghouse to FIFA, which includes the failures. Why? Because FIFA is the one having the teeth in order to potentially lead to fine sanctions to the non-compliant parties. No? So this is the way in which it is structured. It's quite self-explanatory, everything, but I have been asked by different stakeholders to discuss a little bit more in detail always the compliance assessment, because it's the part that is a little bit newer to the clubs. So here it is a little bit of a description of that compliance assessment. It is performed by the FIFA clearinghouse, which again is a licensed regulated institution based in Paris and complying with European Union regulations related to anti-money laundering and the rest of financial transparency regulation. Again, the compliance assessment is performed on both parties, giving and receiving, on new club and training clubs. It is important to mention that no money will be transferred if that has not been passed, of course. The process is relatively simple. There is a risk assessment where we evaluate if the risk is high, medium, or low of the parties involved. Normally, because of the industry of football, I can assure that most of them are high or low, or high or medium, sorry. And then there is a due diligence performed, which deals with, of course, the source of wealth, source of income, ultimate beneficiary owner, corporate structure of the clubs, etc. And after that assessment, of course, there is an acceptance or rejection of the party. The last point to make is also that we are focused on more a transactional approach, which means that every transaction will be considered separately, and the fact that you pass one transaction doesn't mean that you will pass the following one. This is, again, a deliberate idea that we have versus another one would be a client approach, in which you have to perform regular due diligence of all the clients. Good. So with that, this is the end of the, let's say, the process. The clearinghouse, it was in part discussed also last year in FLAR, but I have included all the different updates that we have going through, or we have been going through in the past year. This is a summary of everything that I have said in this process. On the left upper side, you have the three triggers: international transfer, domestic transfer with fees, first professional registrations. You have also the different steps of the EPP review process, then the allocation statement that goes to the clearinghouse, and then after signing of the terms and conditions, there is the compliance assessment and the payment of the parties. Basically a summary of what I have said. This material, as Maya was mentioning, will be circulated to everyone. I will not go into all the details, but here it's important to note also that the consequences of failure, compliance or payment failures, you have all the details, but they include, in principle, a levy, a fine, but in case of a second compliance failure, of course, it can include the possibility of a transfer ban to the new club or the forfeiture of the training rewards in the case of the training club. So there are very important consequences of failing to comply with the obligations under the FIFA clearinghouse. Here you will observe, and this is the introduction to my last part of the presentation, here you will observe some little squares on top with some numbers. Well, those are real data of how the current cases since November 2022 are flowing through our systems, right? Those are the number of the cases that are in the different phases in provisional, review, validation, etc. As of yesterday, we had sent already 19 EPPs with 9 allocation statements, but this is growing on a daily basis. I mean, every day we are already notifying several of those because, as you will notice, most of our cases come from the transfer window in January. Many were declared 15th, 20th, 25th of January. So the process, the time it takes, the 1 month, 1.5 months that it takes means that many of them are very close to being solved and decided right now. That's why you have the majority of the cases now under the completion phase. So I hope, of course, next year, if I have the chance to come here again, or in the different fora, to be able to update those numbers. There will be squares, of course, in the rest of the payment in, payment out, compliance failure, payment failures, etc., etc. So we will be able to fill those with the new numbers. But this is to just show how the system is already working. And again, the last part, which this is something new for all of you, which is the main findings and results of the first 3.5 months of operation of the FIFA clearinghouse, how this is really working, no? You will be wondering which are the numbers, which are the cases, which are the challenges that you are facing. Well, we are hosting all this information in Power BI, in a tool, in a dashboard, which is very agile and very modern because it allows you the possibility to filter with, depending on different factors and have very updated information on the relevant ones. So you have here a dashboard with a lot of numbers that I will try to really summarize. Many people ask us at the beginning, how could you measure the quality of the information? How could you measure how well this is going? So if we have to pick a number to summarize right now how well the system is going, I would pick that one, which is this 62.9%. Basically there we have created a matrix of how much information we should receive versus the information that we are actually receiving, right? So creating a definition of who would be the responsible MA to provide that information. So if you have to say globally around the world, this information is around 69% now. We came at the beginning in November from numbers around 40%, which were much lower, but thanks to accompanying the parties to fill all the information, we are in a relatively comfortable position at this point. Here you have also which are the number of cases that go in, or the percentage for training rewards, solidarity of both, if the triggers have been international transfers, domestic transfer, first pro registration, etc., etc. And here it is very important on the lower right side, you have how, let's say, an average EPP of a player looks like. So these are the years of the player from 12 to 23. and the amount of information of the percentage of the information that you have. Okay, so if you have to summarize, you see that at the very beginning it's a little bit lower, but from the 17, 18 years, it is quite stable already. This allows us a huge number of possibilities. I thought at the beginning even to do a live demo of that, but I think it would have taken a little bit of time. But it allows us to a lot of aspects, you know. For example, one of which is, you know, to sort by confederation, to sort by country, etc. So this is exactly the same graph, but sorted by the different stakeholders. So there you have, for example, on the left side, an example of CONMEBOL, which is even a little bit higher, 71 than the average. But then you can see that there, the quality of the information was probably lower until the age of 16, but then it reached a level in which it went very well. I'm speaking about the left-hand side of the graph at this moment. Or the case, for example, of Mexico, which is quite average according to the global. This is how it looks like. It allows us to see some trends, some things. For example, you will notice here these big valleys, no, peaks and valleys that there are, which are the registration periods that, as it happens in many member associations, there is a brief deregistration, normally during summer, and then registration again of the player, which provokes that little valley, right? So this is helping a lot to us to extract certain conclusions that then will trigger some actions from our side and from the MAs, right? For example, another interesting filter is that to filter the performance of the MAs if they use their own system, if they use Comet or other third parties, or if they use the systems provided by FIFA, because we can find some mistakes that are a pattern, that are general, that will allow us probably to go and find a systematic solution to it, okay? So this is also how the number of cases has been distributed. So in the upper graph, you see the new cases and the ones that were closed. So you saw the big peak there, 951, which was corresponding to the last days of the transfer window in January. That is quite normal. Then the graph has gone a little bit down, and we still have an important number of cases that are ongoing. It is very important for us, and also from the management point of view, to manage the seasonality of the system, no? Because of the transfer windows that will provoke a lot of peaks of those. So it will be very important to try to flatten that curve and try to be able to deal with the seasonality. From all these graphs that you have seen, some findings. The first one is that, again, we are very satisfied with the performance of the system because the clearinghouse went live and it worked, and many PPs were generated, parties are uploading the information, and we are solving the cases. So this is happening. There have been, as I mentioned, more than 4,000 EPPs already created in these first 3.5 months. The quality of the information, as I mentioned, has peaked until around 69%, but it's important to mention that there are some MAs and some important MAs where there is still a lot of work to be done. I also extracted a couple of numbers earlier today about there are 133 MAs that have participated in at least one EPP, so it's quite a high number, and 20 of them in more than 100, so either by declaring or with providing registration information. On the right side, a little bit on the distribution of the triggers. The most common trigger has been international transfers, mainly, of course, because this January window, followed very closely by first professional registrations. Here, it is very important for all of you to be aware as well that many of the first professional registrations or domestic transfers are discarded in the early stages. And why is that? Because all MAs have the duty to report all the domestic transfers with fees and first professional registrations to the system. But after 10 days of inspection, it may be that they don't have an international dimension, so they will not lead to training rewards paid in the framework of FIFA. Of course, you always have to leave those 10 days, because during those 10 days, there can be any other MA which can raise the hand and say, yes, I trained that player, and here's the information. So that's why we have to leave those 10 days, but many of those first pro registration and domestic transfers are actually discarded. We had some issues also at the beginning because, of course, some of the trigger events have happened right before the deadline, so that would go through the whole system. That is an issue that happened. And I would say also that the EPP system and the clearinghouse is allowing us to have a more systematic approach to some compliance matters that we are facing. No? For example, the proof of payment. There is an international transfer with fees that will trigger solidarity contribution. The trigger is the payment of the player, and you know clubs have 30 days to pay. So now we are able to track, okay, this has not happened. After 30 days, the payment has not happened, so it's a good way of identifying compliance issue in a systematic way. And we have already some examples of cases in which, after those 30 days, our compliance team has sent them a letter and they have uploaded automatically the proof of payment, and it has triggered an allocation statement and solidarity. So it's allowing us to tackle some of the compliance matters. Another one, for example, is the category of the clubs. As you know, there is a circular by FIFA by which each MA has the right to put the category of the clubs, certain categories. Some of them have the 4 categories, others have only 3 and 4 categories, etc. So this is allowing us to see some triggers that contain training categories that in theory shouldn't be allowed by certain member associations. And it allows us to tackle that issue again in a more systematic way. I'm close to the end now. We have seen a lot of numbers, a lot of statistics. I'm going to put you a couple of examples of the first two, some of the first two that we solved. This one was a case of a player, male player, going from Italy to Greece. First pro registration, international. So what we found out in the first phase, let's say the first step that I have described among these 3 steps, the first one, we got information that was relatively good, around 70% of the information was there. Then in the review phase, the second part, well, we asked the new MA and the former MA to provide some registration information. The new club uploaded some waivers for the training clubs. They had the chance. We asked those training clubs to challenge those waivers if they had to. They didn't do that, so the waivers were confirmed. And then our team adjusted some overlaps, confirmed the waivers, and decided that, of course, there was, in that particular case, not entitlement to training rewards. There was a couple of days after, another case of that player, also within the framework of the European Union, and this is very important for what I will describe later. The information was a little bit lower at the beginning, but then it was completed in the review phase by the MAs. In that case, as you know, because it's in the EU EEA, the former club uploaded the contract offer to have the entitlement to training rewards. The other club was asked to challenge that and to comment, which didn't happen. And the contract offer was confirmed and valid. So in that case, this is one of the requirements to be entitled to training compensation. So the EPP was finally approved, the allocation statement generated and communicated to the parties. Okay? This is a little bit very normal cases that we have had in these first months. And at the very bottom, you have a little bit of timing. In that case, the EPP was created the 4th of January. More or less after 10 days, it went from inspection to review. Then there was 2-3 weeks about the review and validation, back and forth, and then it was decided a little bit over a month since it was generated. I'm not saying that this will be always the case, because there will be more complicated case, but it can be the case at least. And lastly, a little bit of a summary of what we have found so far and where we are going. I would like to discuss like a couple of conclusions and 4 challenges that we have. The first conclusion is that we are very satisfied and happy with the performance of the system, that is working, and that the parties are able to perform the actions that they are required to. One, on the content matter, on the substance, one of the findings that we have really seen is that there is a high number of waivers that we have found. So and now we have, of course, every transfer goes through us, every first pro registration goes through us, so we see everything. We see very high numbers of waivers. And of course, that can be one of the reasons, if I come back to my previous graph at the very beginning of the presentation, of why the training rewards are not paid. No? Of course, this is one of the conclusions, or some of the conclusions that we can have. Just some challenges or some issues that we are facing. The first one is something that we have to do is striking the right balance between having an efficient, like fast, automatic EPP, but also being complete. This is the question of when to stop. No? When you have an MA that is not responding to the registration information of the player. What is the limit? No? What is the balance that you have to do when you have to really stop and have an EPP that is final without all the information because the parties are not responding? So is there also the balance between the education and trying to contact them again and the possible imposition of sanctions in the future according to the regulations for lack of compliance of them. The other one, again, another balance is the balance between the system being automatic and very fast, but also the parties, the right of the parties to be heard. No? I put already a couple of times the example of the waiver. If someone uploads a waiver, then you have to give the other one the right to challenge that waiver. If a member association has put new registration information of one player, then you have to really give the new club the possibility to upload a waiver. So you have to be a little bit back and forth. So I think there is also a good balance there. And the balance to make all the parties to upload everything in the TMS system interface for EPPs, because you may have in TMS a lot of information flowing and document and transfer agreements, etc., but we are also educating the parties that they really have to put that information in the framework of the EPP process in order to be considered. The last one, of course, is the change in mindset, which is an ongoing process. No? It's something that will not probably stop in the next months or even years. No? The change in mindset implies that, of course, everyone has to get familiar to the system, to go to TMS very regularly, because every day they will have a lot of EPPs to be checked and to be commented upon. But also, another change in mindset has to do with the practice of the clubs and MAs, with the old practice of certain things. And I think here we have already achieved quite a lot, and we will continue to achieve that. One example is the reminder that probably many of you have asked me already related to the 95% on how to deduct the 5%, how to put that into, report that in TMS, etc. Also a very common practice earlier, which was that the new club will cede the responsibility to pay the solidarity and training to the former club. That was very common. Now it starts to lose a lot of sense, to be honest, because in the clearinghouse in Paris, it will be the new club always the one who has to perform the due diligence. So if you have to go through all that, why not just paying directly, and not asking another one and then having to pay back? So I think there are some important points in which there is a change in mindset. A lot has happened already. We have had a lot of compliance already, but still a lot that is still ongoing and for the future. So with that, I would like to conclude. I hope to have shed some light of my initial objectives at the beginning, again, of where is inserted this clearinghouse project within the FIFA strategy. Also, what the regulations and the process say, and also some of the first findings and results of the system and how it goes. So thank you all of you for the attention. Thank you all of you also for participating throughout the process, for helping us a lot in getting this idea, as I mentioned at the beginning, become a reality. So thank you very much, and now I think I will have some minutes for any comments or questions that the audience may have.
Correct. Thank you very much, Cesar. So if we have any questions from the audience, Cesar would now be happy to answer them. You just need to raise your hand, and you have here someone that would like to ask a question. Yes.
Buenos días.
Good morning. This is a question for those clubs that do not have access to TMS, because they do not have professional football players. Normally they have worked through the MAs, but with this new system, what I've perceived is that there's some uncertainty, right? Those clubs feel far from the system. I don't know if you have thought of those clubs who are also training clubs, and many of them, also have these triggers, and maybe whether they could be included with the new regulation. It is clear that now they have access to TMS, but maybe it would be interesting that they could also manage directly the different steps for these processes. Well, thank you so much for your question. This is very relevant. First of all, we need to say that all MAs have the obligation to have an ID for their clubs. All clubs must have an ID in the system so that all the registration information can be registered and sent automatically through the system. This is an obligation dating back to 2020. So MAs have had over 2 years, 2.5 years to comply with this. And we're working hand in hand with them. So this is the first thing to keep in mind. And this is important because when a club has a FIFA ID, it will automatically appear in the system. Also, it is true that there are some clubs that do not have access to TMS, but in that case, it is the relevant MA who can participate on their behalf in these cases, okay? There's also the situation when there are affiliated clubs, and depending FIFA regulation, for these clubs, payments can be channeled through the MA. However, the most important thing to keep in mind for all clubs is that they need to talk to their MA so that all the IDs are regulated, so that all the registration information is not lost, and that it's well reflected in the EPP so that the corresponding payments are channeled through those clubs for training rewards. Thank you, Cesar. Any other question? Hi, good morning. I'm Gersting from Uruguay. I have this question. In Uruguay, we have professional football and amateur football, which is mostly found in the interior of the country. And there are more than 600 clubs that work with the Comet system. And of course, sometimes they receive payments for the solidarity mechanism or training rewards. But the thing is that because of our national legislation in Uruguay, those clubs cannot have bank accounts. So what do we do in those cases when those training clubs find in the situation where they cannot get the training compensation? Well, thank you very much for your question. When we talk about bank account, that's definitely a very relevant topic. We have done some study and analysis of why some clubs do not have a bank account. So, as I was saying, we studied the situation, and the cost of opening a bank account is actually very limited. In general, I have worked in the World Bank, and we actually did many reports on that side, and the percentage of the payment is very low. So this is not really a deterrent, a reason not to open a bank account. The obstacles can come from the compliance side. However, we have been working really hard with some Latin American clubs to urge them to open that bank account, because that is not so hard, and that will actually entail many benefits for them in the future. Having said this, however, the reality is that many clubs do not have a bank account. So when a club does not have a bank account, for example, when we talk about the clearinghouse and the allocation statement goes to the clearinghouse, the fact that a club does not have a bank account, then you have a compliance failure, right? Because you do not have one of the basic elements that you are requested to have. In those cases, when there's a compliance failure for clubs who do not have a bank account, the money of the training rewards will be channeled, as FIFA regulations state, through the relevant MA towards development of football. So we have two things here. We need to raise awareness so that clubs try to open that bank account. That will be very beneficial for them in order to receive the training rewards. And also during this transition period, it is important to understand that payments will be channeled through the MA. So I think it's very important for all clubs to know that if they want to be entitled to receive the money, having a bank account is one of the main requirements they need to comply with. Thank you so much. Thank you, Cesar. I think there are no more questions at this point. So thank you very much. Thank you, everyone.
The next step on our agenda, I would like to invite our head of the Department of the Agents within FIFA, Luis Villas-Boras-Pires, and he's going to give us a nice session about the new FIFA Football Agent regulations. Thank you, Luis.
Thank you, Maya, for everything, for your organization. The level is always super high. First, of course, I wanted to thank you, the Mexican Football Federation, for this collaboration, CONCACAF also. Extremely happy to be here, first time in Mexico. As you know, I'm here to present about the new FIFA Football Agent regulations. Don't be worried, I will not talk about the 28 provisions of the FIFA Football Agent regulations because you don't have time. Half an hour, I was already pressured that I need to be fast because people are eager to have some drinks after. I saw some people already leaving. So I'll try to be as concise as possible. So my idea is basically touch, I would say for now, the two main topics that are currently in force, which basically is the licensing process, because we've been receiving a lot of questions, which is perfectly fine due to a new football agent framework that that the FIFA Council decided to adopt after a long process, but also during the transition period, meaning what happens to those representation agreements that were signed before the adoption, but also during the period that we are now, during this transition period. And I didn't want to touch in all the topics because it's still 28 provision, but at the end of the presentation you will know why I decided to just to focus on this first two topics. So first things first, what happened? Which one is it? Okay, thank you. So what happened was the adoption, finally, of the FIFA Football Agent regulations by the FIFA Council on the 16th of December 2022. Of course, me, but not only me, but all the team, extremely happy that, as Emily said, this came to light and is approved and is in force already. But I wanted to thank you also to all the stakeholders and agent groups from all over the world that participated constructive and constructive feedback to provide the best regulation possible. That we expect, of course, to improve and modernize the transit system. Like I said, there's two periods of that are currently in force. One that is already in force, and the other that will be in force on the 1st of October 2023. But the first that is already started on the 9th of January 2023, it's the process for obtaining a license. So basically, it's the process how to become a football agent licensed by FIFA, and I will try to explain the different path and process to become a football agent license. And then on the 1st of October 2023, then starts the enforcement of the remaining provisions, but also, of course, the obligation of clients to use only football agents. What happened also was the creation of the Football Agent Working Group. Also super excited to have different agents and representatives of other stakeholders to discuss the practical implementation and also any potential amendments in the future. There are 18 members. Like I said, majority are agents, but not only. And the process was simple. We sent letters to everyone to propose their names, and for those who propose, of course, we selected to be part of it, but to try to be as complete and geographically speaking, and I think we managed to do that by having agents from Nigeria, Uruguay, Costa Rica, Mexico, and so on and so forth. This will be a consultative body in relation to all football-related matters and about, like I said, practical implementation, but also possible amendments to the FAR, and also happy that we have already some members in the audience of this football agent working group. So what's happening now? What's happening now is that we have currently two main provisions in force, which is the licensing period and the transition period. So I try to explain that the licensing period is what is the process and requirements to obtain the license. So what are the requirements, whether you can exempt for some requirements, the exam also, the annual fee. So try to be as detailed as possible to this process because it's basically what you're having now, license applications being submitted through the agent platform. The second topic now I want to discuss about is the transition period. So basically Article 22 established the transition period for all the representation agreements that were signed before the adoption. There were signs between adoption and enforcement and after enforcement. So I'll try to explain a bit, although most of the information is already disclosed in the agent section on the FIFA legal.com about the consequences, if any, to those representation agreements that were signed during this transition period, even before the adoption. So let's start with the licensing process. As you know, if you don't know, I'll explain now. There are like two active licensing process. The national law licensing process is not still available because FIFA still didn't recognize any national law licensing process. That's why that process is currently unavailable for everyone that wishes to become a football agent. But basically there are two. We call the exam path and the legacy path. But the first thing you need to know, you don't need to have the license now. You need to have the license when, if you wish to provide football agent service as the 1st of October 2023. Then, of course, if you don't wish to obtain the license, it's up to you. But at this moment, the only thing you need to be is register with the relevant MA to provide intermediaries service. First requirement of the exam path is being a natural person. So in this case, there's no whatsoever any exceptions to becoming a football agent licensed by FIFA. So meaning what FIFA had previously in FIFA player agent regulations, where you had family members and lawyers that could provide at the time player agent services without a need for a license. So this is basically the first requirement. Everyone that wishes to provide football agent services, they need to obtain a FIFA license. The second one is to register in a platform, first step, and within when you register in a platform, then you have different steps where, or different paths, like I said, to select. So we just need to select the exam path, assuming that you comply with the requirements that are established in the legacy path that we'll explain in the next slide. So if you don't meet those requirements, then you need to submit a complete application via the FIFA agent platform on that link that I show in the slide. In 2023, we'll have two registration periods, the one that just started and it will finish in 2 weeks or so, and then another one that starts from the 1st of May until the 31st of July. So during the period, people can apply for the license to become a football agent, and that leads to the third requirement, which is the compliance with the eligibility required. That usually we basically divide in three different requirements in that sense: ethical, conflict and integrity, protection of profession. I will go in detail in that, but basically when you submit, of course, the application, the license application, it's on the football agent to, or the candidate, or the applicant, to do a self-stating saying, I'll comply with the eligibility requirements. And after we receive the information, then of course FIFA will do the first filter, do their own background check on that specific candidate, and also we have all the 211 member association that will assist us on reporting any non-compliance with eligibility required. And of course, if you meet the eligibility requirements, then you will be invited to take the exam in the selected member association. And the selected member association doesn't have to be the one that you're domiciled in. You can select whatever member association that fits you better to your needs, but of course you're responsible to understand what are requirements to enter in that territory or that country where you wish to take the exam in that selected MA. So, third stage, you're invited to take the exam, so you're gonna need to pass the exam to become a football agent. I'll not go in detail now. I will explain with the video and hopefully with some additional information what will be the web exam about, but basically it's to test the knowledge of FIFA regulations. We have already established the 2 dates of the exams. As you know, when we adopted regulation and then published all the relevant documentation on the 6th of January 2023, we provided also appendix and closures to the circulars where we explain all the process to become a football agent, but also explanation notes about the different provisions of the FIFA Football Agent regulations. So we'll have 2 exams, one on the 19th of April, so it will be soon, and also another one on the 20th of September. If, hopefully, you pass the exam, then you receive a notification from the platform to pay the annual fee of $600 US. So this is basically a summary of what is the exam path about. Moving on to the legacy path, because again, based on the feedback that we received from different agent groups, it was felt that was reasonable and proportionate to, of course, to exempt some agents that passed the exam before the establishment of the FIFA intermediate regulations. So basically, this path is to some extent the same and similar to the previous one I just explained. The only difference is you have also a timetable that you need to submit, otherwise you need to take the exam from it's the 9th of January to the 30th of September. Again, legibility requirements, same process, you submit, register in a platform, you select the legacy path, and then you'll be able to provide proof that you were licensed as the FIFA player agent regulations, and also proof that you register as an intermediary between the 1st of April 2025 and the date of approval of the FAR. A lot of questions were raised about what documents I can submit to prove that I'm licensed before 2015, or even what proof I need to be providing if I want to prove again that I'm registered as intermediary. And again, the football agent is the one that has the burden of proof that he was licensed before 2015 and that they were registered as intermediary. The first requirement of the proof that we're a licensed person to the FIFA player regulations, the documents are simple, or you submit the letter from the relevant member association that licensed you before 2015, or card. Sometimes a member association issue a card, and for us that will be enough to prove the first requirements. But then it goes to the second one, which is the proof that you were registered as an intermediary between the 1st of April and the date of approval. And for that, you can be registered as individual, or you are owner of an agency, register again as this intermediary, or you're a director, or you are an employee of that agency that was registered as intermediary. So it's crucial to have that legal person registered as intermediary, so of course, to comply with the intermediaries regulations. And you just need to have once registration during this whole period. So you don't need to have consecutive registrations from the 1st of April until the date of approval. The other qualification that we usually ask is to submit, we need to submit all the documents in English, Spanish, and French. We don't need certified translations for that, and because we receive a significant number of requests that were submitted in some in Japanese, others in German, and we have a small team, but that language skills is not still available in our legal department. So the same thing, the process is, like I said, you submit all the documents through the agent platform. It goes first to FIFA. FIFA will check those documents, but then, and also the compliance with the legibility requirements, and then we send to the relevant member association that you selected as the one that basically licensed you before 2015. And once the member association approves your application, then you will receive a notification from the agent platform saying that you need to pay the annual fee to FIFA. And again, of course, this takes some weeks because FIFA can approve. If today I receive a ticket that someone submit application and I see that all the documents are ready and then there's no issue for the compliance requirements, usually it's fast, but then of course we need the collaboration from the different member associations to approve that application because they were the ones that issued the license before 2015. So it may take some weeks, but hopefully some, of course, member associations are faster than others, but hopefully in a few weeks you can obtain the license. But again, you need the license as from the 1st of October 2023. You don't need the license to perform intermediary service on the next transfer window, or even now if you're renegotiating an employment contract. This is a small diagram of what I just explained. This again, it's available in our agent section in the FIFA legal.com. All the information, I think it's quite clear, but it's also good since you're going to have access to the presentation to have also this diagram explained. So I go try to explain in detail the eligibility requirements and also the other requirements that need to be fulfilled, which is also the exam. And these requirements you need to comply when you submit the application, but across all the licensing period until you obtain the license. So we have the so-called ethical requirements, and of course, as you know, the main objectives of these regulations is to raise the ethical and professional standards for the occupation of agents, to protect players who have short careers, but also to protect contract stability and solidarity. So the first one is ethical requirements. So those that prevents the access to the profession indefinitely. So everyone that was convicted with a certain number of crimes that are listed in our regulations, or they were suspended for 2 years or more, or striking from other regulatory or authority or sports governing body. Then we have the other one, the other two, which is requirements connected with conflict and integrity and protection of profession, which basically is requirements that can be to some extent corrected by the applicant if they decided, of course, to correct, which basically is not to be an official employee of a club, FIFA, confederation, league, or body that represents those stakeholders. With one exception, if you are someone, for example, from the football that we just appointed for the football agent working group, although you qualified as an official, you still comply with the eligibility requirements because we have an exception in our regulations to do that. Then you cannot provide any false or misleading or complete statements, not to hold an agent or the agent not hold any interest in the club. 5 years before the submission of the license application, there is no bankruptcy involved, but also 12 months before the submission of the license application, there are also no interest in betting companies. Again, like I said, requirements that may be corrected, examples of roles that not allowed or don't comply with these requirements is, of course, coaches, clubs, officials, professional players, and referees. Then we have the second one, which is more the requirements that protect the profession, although, of course, now we don't have a license except for some countries like France and Italy. That, of course, probably this will be applied in the future once they become a mandatory license from the 1st of October. But again, is something to protect. So if someone is caught or was found providing football agent services without license, then they will be prevented to become a football agent within the time period. Again, a requirement that may be corrected due for the time period. Now moves to we call the third requirement, which is the football agent exam, and for that I will show you a short video to try to explain what the exam about.
The new FIFA Football Agent regulations have been approved, and individuals who wish to become a football agent licensed by FIFA now have to follow an application process. New candidates, regardless of their profession, must take an exam. So, what should you expect? There will be 20 exam questions with a mix of theoretical and case study questions, and single choice or multiple choice answers. The exam will be available in English, French and Spanish anywhere in the world. The pass mark is 75%. In order to pass the exam, you need to answer 15 out of the 20 questions correctly. If you do not pass, you can reapply at the next available date. The exam will last 60 minutes in total and will take place under exam conditions, facilitated by invigilators at a member association approved location. You are free to choose any listed member association in which to take the exam. You will need to use your own laptop and internet hotspot in the exam. It is an open book exam, meaning you may use FIFA study materials and consult regulations during it. However, you may not confer with other candidates during the exam or otherwise attempt to circumvent the rules. The exam will test you on your knowledge of FIFA regulations governing the transfer system, including the Football Agent Regulations, the regulations on the status and transfer of players, the statutes, the Code of Ethics, the Disciplinary Code, and the Child Safeguarding Toolkit. You may also be tested on additional regulations that haven't been listed here. Check on the Agent platform for the most up-to-date versions of all study materials. For further information regarding the exam, candidates should carefully read and comply with the exam rules that are available on the Agent platform. To find out more, please visit fifa.com/legal.
So basically, I hope the exam is, the video about the exam is clear, but I have really a short summary here. I will not go in detail. The only more information that I can provide is that there will be no domestic related questions in the exam. Like the video just explained, the main regulations will be the ones that are always in the study materials, so always need to check the study materials to see what are the regulations we'll be asking questions about, because you know FIFA is quite dynamic and changes their regulations. So for example, like Emily said, we're going to have another approval of another for the transfer system reform. So those are out for the April exam, but they might be involved also on the second exam. So most of the questions, I would say 40% of the questions will be about the FIFA Football Law regulations. Then RSTP, I would say around 30%, and the rest of the percentage will be about the remaining FIFA regulations. And I think most of the information was already in the video. And again, if you pass the exam, you'll be asked to pay the license fee in 90 days, and for the payment, the FIFA license will be issued. What do you mean by that? It's a FIFA license that allows you to work on the worldwide basis. Of course, probably you need to register in the relevant member association if needed, but it will be able to work in different jurisdictions, something that doesn't happen now because you need to register in different intermediaries or accept different intermediaries regulations. So it's non-transferable, personal, and for an indefinite period. What I mean by that, of course, you still need to comply with some requirements, so ongoing, of course, compliance requirements, meaning you need always to satisfy the eligibility requirements to comply with the continuing professional development, so complete the 20 credits every year, and to pay the annual fee every 30th of September every year. I wanted to raise also some interesting data that we have at the moment. This is, I tried to update this information yesterday because we've been receiving daily license applications. At the moment we have 4,222 applications, exam and legacy path. Of course, the exam is the majority, being legacy path with around 448 applications. We have already 257 license applications rejected or withdrawn, meaning sometimes due to the lack of knowledge of the regulations, some professional players apply for the license, so we explain they're not entitled, they're not eligible to become football agents, so they withdraw, but also they were not meeting the requirements of the legacy path. We have already 145 license issues. Hopefully in the meantime we're going to have more, because there will be a lot of, a significant number of license applications are also with the member association they need to check and to approve, around 300 that could add it on to the license issue, but also there are some applications that are still waiting for the licensing fee payment. Interesting data also for the 2,300 support tickets answers since the 6th of January, although we went live on the 9th. We had already, on the 6th already, people asking why they can apply for the license. Then we explained that we'll be starting on the 9th of January. And also around 1,000 requests for information answer. Some more complicated ones, less, because most of the information it is available. But I wanted, of course, to thank you, the team in Zurich, Caroline, Victor, Tariq, and Julio for being super active and trying to answer to all stakeholders, all the legal, but always also some IT questions, and it's not easy to please everyone, but we try to do our best to provide a proper and a speedy answer as soon as possible. So the first other interesting data that I found here is, of course, UEFA is the most confederations where there are more license applications, whether for exam but also for the legacy path. Top 10 nationalities, 3 British, French, and Spanish are the most predominant for applying for the license. Exam attempts, we'll try to explain. So when you submit a license application at the agent platform, when you're approved by FIFA and the member association to become a football agent, you are giving access to a practice exam. It's like a mock exam that you can take to experiment what will be the exam day. We have a few people already that tried, 422, 80% so far they fail, and another 20 they pass the exam. And also interesting data about the frequency agents distribution. If you can see, probably it's too small, but once we make available, we can see that the 36, between 26 and 38 are the most common agents, or the highest agent age that usually apply for the license application. So this is all for the licensing related part, so I'll move on and to the transition period. So basically I tried to explain briefly, because it's not easy, and that was one of the first questions that were raised on the first week that we went live, is what happens with those representation agreements that were signed before the 16th of December? They are being signed after the 16th of December and after the 1st of October 2023. I will start with the first case scenario, which basically are representation agreements entering into prior to the 16th of December, which is the date of adoption. So those agreements remain entirely unaffected, whether the transaction occurs now or after the 1st of October 2023. However, such agreements may not be extended. And of course, the agent chamber will not have jurisdictions, regardless if they have international dimension or not, to claims connected with those representation agreements. So that's the first case scenario, representation agreements before the entry into the adoption of the football agent regulations. Second case scenario is representation agreements entered from 16th of December and up to the 30th of September. So up to the 30th of September, those agreements remain unaffected by the football agent regulation. If a transaction happens connected with that representation agreement during this period until the 30th of September, those representation agreements still remain unaffected because the transaction happened during a transition period. But once those representation agreements don't have any transaction, there was no representation, there was no transaction happening during this period, then on the 1st of October, those agreements need to be amended to be compliant with the FAR if needed. Of course, if they already comply now, there's no need to be amended. And for those representation agreements that had transaction during this period, the FIFA Agent Chamber also is not, will not have jurisdiction to those connected claims. And finally, the last scenario is, of course, representation agreements that were entered as from the 1st of October 2023. Then, of course, they need to be full compliant with the football agent regulations, and provided that those representation agreements have sufficient international dimension, then, of course, the agent chamber will have jurisdiction to deal with those disputes. So, I just have a final slide because, of course, I started the presentation saying what happened, what is happening now, but also what's going to happen in 2023. Of course, we know that the regulations will be enforced by the 1st of October 2023. The obligation to use licensed football agents to provide football agent service will start in that date. Same as, like Emilio said, the agents chamber will operate as from the 1st of October 2023. But I wanted to share two initiatives that we will release soon, hopefully next week, we'll see. And the first one is a publication of a frequently asked questions, where we answer approximately 900 questions that were raised during the consultation process, but also from the first 2 months that we went live. Again, this is an additional and another source of additional guidance to football agents, to member associations, to coaches, to players, to clubs, to everyone, legal practitioners, to everyone that is eager to understand more about our regulations. Hopefully we'll clarify most of the topics that are being raised, and then we have been answering through by email, because everyone should have access to all the information for transparency reasons. This is the first edition. Of course, the idea is to continue updating this document, because if you find any additional questions, feel free, that it is not in the FAQs, feel free to reach out to us. We're more than happy to try to answer and update this document. And basically, it's the FIFA administration views about the different topics. And finally, we hope to have an online conference to understanding the new FIFA football agent regulations. So FIFA decided to organize this conference, hopefully beginning of April, to present the key principles of the FAR, explain its application, but also in the practice and trying to answer in a similar way. It's a bit similar to what we're having now, with questions can be raised during streaming on live, and hopefully next week or the next few weeks I'll be able to provide more information about this conference that hopefully will be able to provide more clarity and give at least a good explanation with practical examples how the new FIFA football agent regulations will be applied. And that's why today I focus more on the transition and the licensing period. That's all for me now, so thank you very much, muito obrigado, and I'm happy to answer any questions.
Not sure if we have any questions or if you prefer to go to the break. Looks like the second one, but just before you leave to the break, we will have now a 30-minute break. Afterwards, we will have 3 great presentations about the transfer reforms, the Code of Ethics and Disciplinary, what has been changed, and the CAS cases in 2022. See you in 30 minutes, and thank you very much. And just to remind you, tonight you're all invited and we hope to see you all in the cocktail at 7 in the evening. Here at the hotel in La Residencia. And whatever, and whatever. months here in Mexico City. I hope that you enjoyed the break, and the ones that are watching us on the live stream, I hope you could have a coffee, and now you're back in front of your screens to be able to continue with the session of the FLAR on the first day. So let's continue with the second part of the day. We will start now with a presentation about the most recent football transfer system reforms, minors, private academies, and the new regulations governing trials. For this, I would like to invite to the stage Jan Kleiner, FIFA Director Football Regulatory, who will give you this next session. Jan, muchas gracias por estar acá.
Jan, thank you so much for being here.
Muchas gracias.
Thank you so much, Maya. Thank you very much. First of all, I would like to thank the Mexican Football Association for their hospitality and for hosting us here in Mexico City. It is a great pleasure to be here with all of you. Thank you so much as well to my team. I am very lucky to be here giving this presentation. However, behind all this, there's a team, an exceptional team that works very hard, so I would like to thank all of them.
Switch to English to make things easier, I guess, for everyone. The topic that I will be speaking about, as Maya already said, the reform of the football transfer system, with a special focus on the most recent reforms concerning minors, private academies, and trials. I will split the presentation basically in 3 blocks. We'll first do a quick look backwards, just to give you some context, some background of the transfer reform, the reform of our transfer system. Then I will focus on the present, on the changes that we have just recently adopted, and then to conclude, we'll also do a quick look ahead on some things that are on the horizon, because as you know, we are not done yet. The transfer reform is an ongoing process, a very important process, and I will at the end speak just a bit about the remaining topics that we will be working on. A look back, this is a gentleman that I certainly do not have to introduce to you. You know who this is. This is Jean-Marc Bosman, a football player who had an important day in court once in his life. You know this. In December 1995, the European Court of Justice handed down the by now very famous Bosman ruling, which put an end to the transfer system as it had existed until then, a transfer system that had consisted of, I would say, special principles concerning transfer fees that, for example, were due even if an employment contract of a player had expired, also consisting of quota for foreign players. The European Court of Justice in December 1995 put an end to that system. What followed were important discussions, not always easy discussions, discussions between important stakeholders, between the European Union, European Commission, FIFA, UEFA, other stakeholders, to establish a new transfer system, the transfer system that we know today. As you all know, this system mainly consists of the FIFA regulations on the status and transfer of players, the FIFA RSTP, which is built upon 4 main pillars, you could say. The first one being the principle of contractual stability, then the principle of encouragement of training and education of young players, meaning training compensation and solidarity contribution, as you all know, and the 4th pillar, protection of minors, which will be an important topic for the purposes of this presentation. Now, this regulatory framework, as we see, dates back more than 20 years. In 20 years, if we look at the pace at which life is changing, the pace at which the world is changing, the pace at which football is changing, 20 years is quite a long time. And ever since, the football market has evolved. It has changed significantly. What do I mean with that? We can simply look at numbers. And as you know, numbers don't lie. These are the statistics of the numbers of transfers. There has been, and you see this on the slide, since 2013, a massive increase in simply the numbers of transfers that are occurring. And we have an increase basically throughout all parameters, the type of transfer, whether it's a transfer with transfer fee, without transfer fee, an increase in the number of clubs involved, an increase in the number of member associations involved. So we have an increase already in those parameters. Equally, when we look at the spending on transfers, the money that flows because of transfers, we have a massive and constant increase as well. Again, looking at the numbers from 2013, we go from roughly 3 billion to what we have today, around 6 billion, roughly an increase by a factor of 2 or even more. You will see on the graph in the years of 2019, 2020, 2021, a small downturn, you could say, but that there is unfortunately, a very simple explanation for that, and that is COVID-19, which of course not only had an impact on the lives of everyone, but also economically speaking in terms of sports, there was an impact, and you see that on the graph, but overall, it is absolutely beyond question that also here we have a constant and massive increase in the numbers. The same applies when you look at the value of broadcasting rights. As you know, in nowadays professional football, broadcasting rights are an extremely important source of revenue for every club, for member associations. And just looking at the numbers, if you compare 1992, 1997 to 2016, 2019, there is an exponential growth in the value of broadcasting rights and in the revenue that is generated through the sale of those broadcasting rights. Now you may say this in itself is not negative. That is simply the evolution of economy, the growth of economic volume. The problem is, for football, this has led to certain very concerning and worrying trends on today's transfer market. In particular, if you compare today's transfer market with the original objectives that were based, or on which the transfer system was based after the Bosman ruling. And it could be established, unfortunately, that the original objectives were no longer being achieved. For example, today's market is mostly driven by speculation and not by the principle of solidarity, meaning that elite football would generate most revenue, which would then be redistributed back down to grassroots football. We have a market that is driven in that sense by speculation, that there are wrong incentives on the market to make as many transfers as possible in as little time as possible. That obviously also puts contractual stability into question. We have another problem that clubs training and educating young players do not necessarily receive the training awards that are due, thanks to what Cesar so brilliantly explained. Of course, with the clearinghouse, we will be able to close that gap. However, as I already said, there is a problem in relation to contractual stability, problems associated to agents, as Luis had explained, and overall concerns also in relation to competitive balance, because you can see nowadays that a lot of the financial power, you would say, and also sporting power in a sense, is concentrated on a relatively small number of leagues, member associations, and that overall puts into question competitive balance. Now, what to do about that? FIFA reacted. FIFA started a wholesale reform of the transfer system, and it established a roadmap. As you know, our president mentioned it in the welcoming speech. In the vision of FIFA 2.0, there was one key objective of seriously revisiting the transfer system with all stakeholders. And that last part is a very important part, together with all stakeholders, because stakeholder engagement has become really one of the key pillars of this whole reform process. And this is not just a marketing slogan. There's tangible and concrete evidence of that. In particular, the FIFA Stakeholders Committee, which was established, which brings to the table all important stakeholders of today's professional football. In its very first meeting, March 2017, the Stakeholders Committee defined the reform of the transfer system as a priority. Just quickly, we can look at the timeline, but before we come to that, there's a point that I really want to emphasize, that nowadays all solutions need to be agreed by all stakeholders. That is not always easy, because you have to find a consensus between sometimes conflicting positions. That is normal, that is a part of an engagement between stakeholders, but it is for sure the right way how to modernize and reform a transfer system. So we have the European club associations, our friends here also present in the room, FIFPro, the same, very important, FIFA member associations, confederations, FIFA itself obviously is part of that process, the World Leagues Forum, other clubs, non-ECA clubs. So we bring all these stakeholders together to a table to reach, hopefully at the end, a consensus on reform programs. Now you could say, well, that is actually a fundamental change in approach. If we look at all these nice historical covers of the old versions of the regulations, looking back a little bit, I would say between 1991 and 1997, regulations were simply imposed, top down. Here's what we think is correct as regulation, take it or leave it. Or basically you have to take it because you're bound by these regulations. Then in between 2001 and 2017, there was a certain form of collaboration, but actually only as from 2017 going forward, I think you can say that there is really a process that is very close to what in other sectors you would call collective bargaining, where you have the key stakeholders, employers, employees, other stakeholders at a table agreeing on the content of the reform. Sorry, I just jumped one too fast. Here we go. This just very quickly, a timeline, you know most of it, we've spoken about it already, so I'll be very short here. In June 2018, a first important package, you could say, were urgent matters that had to be addressed. There were serious problems concerning abusive behavior towards players, as well as the problem of overdue salary payables that was addressed very quickly and efficiently, I think, with amendments, specific amendments to the RSTP. And then you see on the slide the three main reform packages. Package 1, clearinghouse, as Cesar has explained. Package 2, agents, as Luis has explained. Specific rules on loans and training rewards. As Emilio said, there are interesting discussions that are continuing, that will continue. We then had 2020, 2022, what I labeled here as a special package. Of course, there was the period of COVID-19, which demanded and asked for specific regulatory action. Annex 7 to the FIFA RSTP caused by the tragic war of Russia against Ukraine. And in addition to that, specific rules concerning coaches, and in particular, very important rules concerning the protection of female football players. And now we are in the phase 2022-2023, the one marked in red, Reform Package 3, consisting of minors, and I'll speak about those elements in a few minutes. Then registration periods and unemployed players. It was mentioned already. I'll speak briefly about that towards the end of the presentation. And then what is usually labeled financial regulation, in reality Article 17. I'll also have a few words on that towards the end. So let's look at those most recent reforms. Minors, private academies, and trials. Very important package in particular because, as you know, the protection of minor players is of key importance for FIFA. And let's just look at a quick overview of what these reforms consist. First point, humanitarian exception. Article 19 of the RCP, you will all be familiar with that provision, you're all experts. The provision concerning the principle that international transfers of minors are prohibited, but there are specific exceptions. And this very important humanitarian exception was amended to, I would say, provide the needed flexibility so that we can apply this rule in a common sense approach and not prevent young players in very tragic circumstances from being able to play football. And I will explain in a minute how that works. Second point, private academies. One could say that academies that are sometimes established as purely private entities, they operate, and without putting this in a too negative way, but sometimes they operate somehow below the radar of FIFA because they're outside the regulatory framework, and it is a challenge to have the right tools, to have enough visibility also on what happens in private academies, and very important reporting obligations were established in that context to ensure also that there are no abuses in that context of minor players. Last point, for the first time, FIFA created a detailed regulatory framework for trials. Most importantly, this provides legal certainty. It provides clear rules. For example, maximum permissible duration of trials, which are the types of matches that a trialist can participate in. For a certain time, that was not so clear, and with this detailed legal framework, we provide this regulatory clarity and legal certainty. So let's look at this in detail. First point, so-called humanitarian exception. You know that the principle is international transfers of minors are prohibited, and there are various exceptions. Now, this is what I usually say a certain dilemma, because on the one hand, a prohibition, one could say, and simplifying maybe a little bit, a prohibition is needed to avoid abuses. But at the same time, we should never forget that we are speaking of minor players. And what you do not want is to be overly restrictive in applying this prohibition. But then again, the more flexible you become with granting exceptions, the more you may open the door for abuses. So that's a general dilemma, but it's our task to deal with this appropriately. And I think the amendments to this humanitarian exception show very well that we really try to adapt these rules to real life, to use common sense when we apply these exceptions, and I will now try to explain how this works. So this is in the context of Article 19 of the RCP, protection of minors. Don't worry, I will not read this all. You don't have to read this all. This is just where this exception is where you'll find it. Paragraph 2, letter D, this humanitarian exception. The main idea here is that a player has to flee his or her country of origin for humanitarian reasons. For example, war. Has to leave that country without parents. The player comes to a new country and has to make this transfer, so to speak, due to, for example, a threat against the life of the player or other circumstances that fit within this humanitarian consideration. Now, previously, there were certain formal requirements, and that was not always reflective of real life. It was initially, in the earlier version of the regulations, it was required that the player meets I would say, certain formal threshold. That, of course, depends a bit on the legislation of the respective countries, but typically, you'd say you would either have to formally be recognized as a refugee or as an asylum seeker. Every state legislation has certain formalities that apply to that. Now, sometimes you simply cannot reach that formal threshold. And in order to have more flexibility and to be able to react to situations where real life is not that simple, where one has to recognize that a player is vulnerable and one should not prevent a young player in such circumstances from being registered, now the new rule gives that flexibility in the sense that it is also sufficient that a player is recognized by state authorities as vulnerable. Of course, it is also true that one has to remain careful that this doesn't open up the door to abuses, so there are certain limitations as to the type of clubs with which a player can then be registered. That depends on the status that a player has. If there is a more formal recognition as refugee, a registration with a professional club is possible, or a subsequent domestic transfer to a domestic club. Whereas if you have that, I would say, slightly lower threshold of only being recognized as, for example, asylum seeker or vulnerable person without reaching that formal threshold, then a player can only be registered with amateur clubs and can only be domestically transferred onwards to amateur clubs until the player turns 18. Second point, private academies. As I said, the main challenge here for a governing body is to have enough visibility. If purely private entities operate an academy, it is not easy to have visibility, and the tool that we now apply and the way in which these rules were adopted, Article 19bis of the RSTP, are basically through reporting obligations. First of all, there are clubs that operate academies, where it is clear this academy has a legal link or a de facto economic link to a club, right? That exists, that is perfectly normal. Clubs operating such an academy, they have reporting obligations about all minors attending those academies. Now, sometimes these academies are not operated in the same territory in the sense of a member association, not in the same territory as the club, so somewhere abroad. Then the reporting has to be made towards the MA where the academy operates. Members associations then must request all academies that do not have such a link to report all minors attending those academies. That is again with the aim of having as much visibility as possible. Member associations also have the obligation to report wrongdoing and take all measures to protect and safeguard minors from potential abuses, and this is certainly a point that is of importance and a point where we certainly all agree that this is absolutely key as well to protect minor players. In addition, as you surely know, each member association has to keep a register of players who attend academies. Clubs wishing to collaborate with academies, they also have specific reporting and safeguarding obligations, and then specifically for minors who, specifically to foreign minors who attend academies, member associations must report those, and now that's important, together with a prima facie analysis of whether the requirements for an international transfer of these minors would be met, and that is mostly again to have as much visibility as possible to see where there are possibly indications that an academy, for example, would suddenly have systematically a lot of foreign minors. That would likely trigger at least an investigation to look at whether there's the risk that this academy could be abused to circumvent the rules, the restrictions concerning formal transfers of minors. Last point, trials. Very important, you all know trials are a reality in football. Before we had these amendments, there was, I would say, a lot of uncertainty on the market. When can I do a trial? Are there requirements to register a player, or can I take a player on trial without registering the player? Or am I then at risk that someone says, well, you're actually circumventing the rules concerning international transfers, registration, etc. What FIFA did was, in consultation with all its stakeholders, establish a regulatory framework for trials. A key point here is the FIFA trial form that is available on FIFA.com. This trial form has to be completed, as a principle, completed and uploaded to TMS no later than 10 days before a trial begins. And in that trial form, certain key elements of that trial have to be agreed. Conditions concerning, for example, accommodation, travel, meals, expenses, etc. It is also established that there is a clear duty of care towards the trialist. For example, in what concerns payment for medical treatment, in what concerns injuries that may be sustained during a trial, because before that may have actually quite quickly triggered a dispute. What if previously you were on a trial with a club in a, I would say, pretty much informal way, and then you get injured at that trial? Who bears that responsibility? And with these rules, we have a clear framework that answers those questions. There are also rules concerning the duration of the trial. How long can a trial be? Because that was also a source of a lot of questions before we had this regulatory framework. Then the point that trialists are formally allowed to participate in friendly matches without being registered for the club where they are on trial. That is, of course, an exception to the otherwise existing system that you have to be registered with a club. Now, these rules, they make clear that trialists can participate in friendly matches. Another important point is that no payments may be asked for or paid connected to trials. The main idea here being that we want to avoid that there are suddenly wrong financial incentives in the context of trials, because the whole purpose of a trial is not to pay money to someone for that, and therefore payments linked to trials are prohibited. Minor trialists, very important because often players are young when they go on trial or when a club wishes to have a player on trial. There are specific rules telling us when those trials and under which circumstances these trials are permitted. For example, concerning minimum age of the trialist, concerning the fact that always the written permission of the parents is required, that has to be provided together with the FIFA trial form. A club must designate a specific employee as a point of contact for the minor trialist so that the minor trialist knows in case of problem, this is the person I have to go to, this is the person that is responsible for me to provide a very stable framework for a minor trialist, and I think that is a very, very important point. Additionally, of course, there have to be ideal conditions of accommodation, living standards, coverage of expenses, etc. And for minor amateur trialists, there is a duty to inform the trialist's original club about the trial through the FIFA trial form as well. Last point, minor trialists, they may attend a maximum of 2 trials per year, also to avoid that there, as you imagine, if there were to be a large number of trials, that could create a lot of instability for the development of the minor trialists, so that there is a clear maximum of the number of trials that can be attended. These were the recent reforms, and I'd like to take this opportunity to thank all the stakeholders for the very constructive discussions that we had. We are very happy that we could adopt these rules. And with that, it's time to look ahead. Because as I said, we are not done yet. The reform of the transfer system, the goal of modernizing the football regulatory framework, that doesn't stop. It continues to be very important. And we have further work to do. As Emilio mentioned at the beginning, we hope to very soon approve new rules concerning registration periods and unemployed players. These rules, they consist basically of 2 pillars. The first pillar following the idea that more flexibility should be or will be given to member associations as to how they can allocate the number of weeks for registration windows. Because there was always the problem that if member associations do not operate the same type of season, meaning a dual calendar year season or a season following a calendar year, that created certain competitive disadvantages if you do not have the same registration windows. There was a general concern that more flexibility would be needed together with the stakeholders, and I thank them again for the very good discussions we had. We were able to reach a consensus to have more flexibility in that point. And the second pillar, also very, very important, that more flexibility will be granted to unemployed players, players that are out of contract. What we want to prevent is that there are overly administrative or regulatory hurdles for them to find a new club. The remaining part that is for the future, so-called financial regulations, Article 17, will certainly also be very interesting, very complex discussions, as I would imagine. This is for the future. With this, I conclude. I promise to be short. I promise to be in time. Of course, I'm very happy to answer any questions that there may be. But already now, thank you very much for your time and attention.
Preguntas para Jan?
Are there any questions for Jan? The mic is coming up.
Hi, Jan. Thank you very much for your presentation. It was really great. I'll switch to Spanish now. Te quería preguntar, Jan.
I wanted to ask you about academies. How does FIFA expect to enforce this obligation for member associations to register academies? And I think it would be even harder to register players. So how does FIFA expect to enforce that?
And of course, the first thing is, I think we will see this going forward. The main idea and the main problem that we had is a problem of visibility. Now, how do you resolve that? What ideally, you would just say, well, we just bring all of these private entities within our regulatory framework, but this is, for legal and regulatory reasons, not possible. So the only way to do that is to impose reporting obligations on member associations. Now, at the end, it will depend on each case. If there is, at some point, a question of a possible compliance failure, one would look at, well, did, for example, that member association take the best efforts it could to report everything that they saw, or was there maybe a problem in those efforts? But at the end, a lot of this will depend a lot on the circumstances of the specific case, but the main idea really being to have that obligation on member associations, and we fully trust and we fully rely on our member associations that they will make all those efforts, not least because all of this is about the protection of minors, which is important not only for FIFA, but also important, of course, for every member association.
Tenemos otra pregunta por aquí.
There's another question over there.
I'm from Uruguay here. Since the last years, Uruguay received a lot of people from Venezuela, Colombia, because of immigration movements. Will FIFA consider that as an exception of human protection or not?
Thank you. It's a very good question, very important, because the humanitarian exception is an important exception. Unfortunately, now I'm reminding myself a bit of my earlier life as a lawyer. I have to give you a little bit of lawyer's answer, which is it depends. Because that's the truth, it will depend on the specific circumstances of each case, but it is very clear that our approach will be one of common sense to see whenever there are really humanitarian reasons, when players have to flee their country without the parents, it should not be the idea to be overly restrictive to prevent those young players from playing football. And that is really the underlying thought of that amendment, to have the necessary flexibility and not to be able to rely on certain formal requirements which in certain states are maybe just too high and which sometimes really do not reflect real life circumstances. So yes, it can very well be, but at the end, and I'm sorry for that answer, it will depend a little bit on the circumstance of each case.
¿Alguna otra pregunta?
Any other questions?
My name is Mohamed Sidat, Head of Professional Football at Confederation of African Football. I think the Academy's matter it's crucial, at least for us in Africa. As you know, we have a lot of players moving to other parts of the world. And from an experience perspective, one of the issues that normally we have the member associations coming to CAF, and it's that I know, for example, in Ghana, in Mauritius, for example, there are academies right now working there, but have no link at all to the MA, which is, this is really unacceptable, that you have academies operating, and at some point these players are not part of the football ecosystem, and then they are transferred abroad. So I think here, as a suggestion, you know, FIFA and the confederations could work on a sort of licensing system for academies. You know, obviously FIFA could establish some general principles and guidelines, and then each confederation could then again tailor-made to the respective you know, football ecosystem. Thank you.
Thank you, Mohammed. And you see, this is precisely why the FLAR is such a wonderful event, because this is precisely the type of feedback that is extremely helpful for us. All ideas are welcome, and as Emilia always said, we are not perfect. We will never pretend to be perfect. We will never pretend that our regulations are somewhere near perfect, and all these exchanges and this feedback definitely helps us very much, and I would encourage everyone, and I will be thankful to everyone for criticism, questions, whenever we have new regulations. It is also for us important to have the feedback of those who are actually active on the market, so thank you very much for that input.
Well, with this I think we conclude, so thank you very much, Jan. Thank you. So now I would like to invite to the stage Carlos Schneider, FIFA Director of Judicial Bodies, who will give us an overview of the most significant changes of the FIFA Disciplinary Code and FIFA Code of Ethics. Muchas gracias, Carlos.
Thank you, Carlos. Hi. Thank you. I'm a bit nervous. Not so much because of the floor meeting, but because there is a match coming up, a classic match. I cannot say who I'm rooting for, and my outfit has no hints for you to guess on, but I think by the end of the presentation you might have a rough idea. So first of all, I will start my presentation in Spanish, which I think is most appropriate given that we are in Mexico, and then I will switch to English because the presentation was prepared in English, and I think I can fare a lot better in explaining the changes in that language. But to begin, I would like to thank, obviously, the Mexican Football Association, and in particular, Inigo, with whom we have made great friends. And then from the disciplinary viewpoint, I think it could be said that we have had a meeting of minds with the Mexican Association, and the result of that understanding and those discussions that we have had have led to the fact that in the case of member associations like the Mexican Football Association have had a key role to play in reaching the results that we now see. So thank you, Maya, and thank you, Emilio and Leo, for inviting me to join you today. I started with 2 presentations in 2019. Last year, I had a 1-hour presentation. This year, I've been given 45 minutes, and Emilio has already warned me that we are running short on time. So I think there is a preliminary message that I have not yet interpreted fully and that he has yet to see the results of. So I would like to welcome all those of you, both those of you who are here and those who are not. And in particular, I'm thinking here of my wife and children, my 6-year-old twins. I know they are watching this session as they have dinner, so please finish your plates and be good. Okay, so let me see how this works. I will now start with my presentation. Good, thank you. Right, so as I said, I will now switch to English.
The presentation of today is, I hope it's interesting for you. It is definitely for me, because the intention here is not to go through all the changes that we had, but only to give you a little bit of an overview of what the new codes are about. And in this overview, what we should get at least is those changes that should reflect the intentions of FIFA when they release that new edition. You have here the QR is one for the code, disciplinary code, the other one for the ethics code. We also prepared 2 more documents in this regard, and that I will mention afterwards. So, so normally I do presentation by moving. So, my intention now is to take it with me, but I will try not to do that. So, new codes, 3 years after the last revision. The last revision was already a revision that we did in depth. We did, I think, very good things in terms of the structure, the reasonings, the changes, the number of articles that was reduced to more than half of what it was before. And now, 3 years after, we are back to a new revision. And the new revision is indeed, again, something that it's done in depth, and which is the result also from our discussions with different group of interest, mentioned already by Emilio. IAF has been extremely important in those discussions. The same goes with UEFA, the same goes with ECA, with FIFPro, and maybe for the surprise of some of you, also with the FAIR Network, who has been really, really cooperative in introducing something that should help both to protect the discrimination in football, but also the member associations for being too much damaged by our sanctions. Here, two QR, they are already on the web page. It's the overview of the changes, one for the disciplinary code, the other one for the code of ethics, and here you see everything, all that has been changed in both codes, with the new wording, with the reasoning behind, and also the goal that we have been pursuing with the changes. I think it's something good, something also in line with also Emilio's view on being transparent, being honest, and provide you with all the elements to criticize us, obviously, but also if you see something that you are happy with, that you can also be happy with that. So, contains, so that you see the depth of these changes, contains more than 70 changes, around 52 provisions, and it also includes 3 new provisions. So as you can see, it's quite a strong exercise, an important exercise that we did together with you, because you are representing all the groups that we have been discussing through these last 3 years. So we start
in keeping with its vision to modernise and improve football's regulatory framework, FIFA recently approved key changes to its disciplinary code. In line with FIFA's commitment to achieving financial justice, the new edition of the disciplinary code has undergone some significant changes and is now providing additional deterrent measures to prevent debtors from delaying the payments of amounts due to creditors. Indeed, the disciplinary committee will now be entitled to 1. Impose provisional measures on clubs to prevent them from recruiting new players. 2. Order debtors to pay a higher rate of interest to creditors in some specific cases. 3. Sanction member associations that fail to implement decisions issued by their respective decision-making bodies. And 4. Enforce private settlement agreements. In addition, FIFA will be fully responsible for the enforcement of disciplinary measures imposed by the Football Tribunal, as well as for any related issue. Furthermore, greater protection will be provided to victims of discrimination, as they will now be considered parties to the relevant proceedings, thus enabling them to be notified of the decision and to subsequently appeal it. The disciplinary code has also been amended to provide greater transparency and predictability for stakeholders through the addition of an annex containing a predefined list of sanctions for various offences. Further improvements have been included in this new edition of the code, specifically to introduce independent integrity experts who will support FIFA's judicial bodies by conducting the necessary investigations. Strengthen FIFA's fight against match manipulation through the introduction of the integrity experts, but also by requiring member associations to inform FIFA of any sanction pronounced against match-fixing activities. Foster the accused's right in proceedings related to the worldwide extension of sanctions. Extend the scope of competence of the disciplinary committee in relation to friendly matches, but also to enable it to investigate and prosecute serious infringements that do not fall under its exclusive competence, and ensure smooth and efficient proceedings before FIFA's judicial bodies, thanks to various amendments aimed at simplifying and speeding up those proceedings. All these changes and many more can be found in the new edition of the FIFA Disciplinary Code, which has come into force on the 1st of February 2023 and can be accessed on the dedicated portal at legal.fifa.com. All in all, these changes will provide all those under the disciplinary umbrella of FIFA, including FIFA's member associations and other stakeholders, with additional strong tools to protect football and its integrity.
So, this is more or less the content of my presentation, I have to say, but it goes even beyond, because it also introduces you to some of the changes that I won't discuss today. But let's keep it narrow in the sense of giving you again these 3 aspects that should at least reflect the efforts and the intentions of FIFA when it decided again to revise the code. So here we have the 3 pillars: is the protection of victims of discrimination, the enhancement of financial justice, and you will see in which extent as well, and the improvement of FIFA's capacity and skills to investigate, but also to provide the adjudicatory organs with enough tools to, well, not enough, but with more tools to decide better on cases. So we start with the discriminatory behaviors. The first thing, and this is important, this is also something that we have been discussing with organizations like ECA, but also with FIFPRO, mainly with FIFPRO, was the main idea was to give voice to the victims. We know and get feedback from everywhere when we take a decision and people, and mainly, and I agree in some extent to them, that they don't understand the outcome. And when I say they, is normally the victims. Sometimes we close cases because we have a recent case, very recent case where there was not enough evidence, according to CAS. And the victims don't understand that outcome. So what we want, and to at least to give the message, is that the victims will still have the right to move with the case forward, even if a decision has already been taken. That means that they will be considered as parties of disciplinary proceedings. They will have the right to request the grounds. They will have the right also to access to the file and decide after if they want to appeal it or not. So we think it's a good exercise, a good and a transparent exercise towards the victims and providing them that voice that they were demanding for quite some time. But the question now is, who is a victim? So we cannot open the scope to everyone feeling they are a victim because they have been affected by a chant, or they have been mentioned by, or they have been mentioned by some gestures or so. So we need to really specify who are the victims, and this is also something that we are trying to provide with this new code. What is it exactly? First, they need to be the directly addressed individuals or directly addressed subjects. So indirect subjects, it doesn't count. Direct subjects, for instance, and I think the clear example is players, when they are racistly abused by anyone on the field of play, so they will be victims in the definition of this code. Second is, let's say, the legal status of that victim. So, for instance, only those falling under the umbrella of the code will be regarded as victims. We know there are ethnic groups, group of fans, supporters that can feel that they have been directly addressed, but we have to keep these procedures within the scope of FIFA, and within the scope of FIFA is only the personal scope applied in accordance with Article 2 of the disciplinary code. Then, focus on education, prevention, and security. And this is what I bring back our conversations with Íñigo from the Mexican Federation, where he exposed an issue that I think we all can understand. From our time at UEFA, where we had the chance also to implement what we called back then the 3-stage in regards of discrimination. That means that if a club is responsible for a first offense, it's a partial closure. For a second offense, it's a match behind closed doors. And for a third offense, whatever can be decided. That was reflected afterwards, short afterwards, at FIFA. But obviously, when you are bringing something from another place, this something needs to adapt to this new place. We understand that UEFA, for instance, what it, at least from our perspective, what this rule roots, is not the same as FIFA. The reason is that UEFA is operative in the sense of competitions, Every month there are two main competitions ongoing. Every year the same big competitions are still ongoing. So it means that it makes sense to have this harsh approach when they can redeem themselves maybe in the next month or in the next 2 months. It's not the same for us at FIFA, where we still are playing every 4 years. And it's, I think, also not beneficial for football when you implement such a big and harsh sanction and then 4 years have to elapse after they can again demonstrate that they have done their homeworks. So, where have we been moving forward? Again, I want to especially thank Fair Network because they have been very much involved in this change so that we can also take out or at least reduce the view that we have that someone could have over this association in terms of that we only want to punish. It's not true. We are fighting against racism, and the fight, and this is the input of FIFA, needs to go through these 3 pillars: educational activities, stadium security, and also exploring new partnerships. So what is the rule saying? The rule is saying that if you are responsible for a racist behavior, then in cooperation and coordination with FIFA, you should agree to elaborate a plan that will include a plan to ensure action against this racist behaviors or future racist behavior. And what is the result of that? Very important one for from our perspective, still mainly for the member associations, is that the competent judicial body may deviate from the above minimum sanctions, which is this 3-stage procedure. So it gives the opportunity to the member associations to be active or have an active, very active role in coordination, also making FIFA responsible to ensure that action so that they don't need to suffer the full consequences of this provision. So we move to the financial justice and failure to respect decisions, what is, my view, wrongly called as enforcement of decisions. So what is the goal here? The goal here is to narrowing down the margin of action of debtors. We know that debtors are clever, not so clever to pay, but clever to avoid the payment or to delay the processes. And the goal, and the main goal, is to reducing that room they have to maneuver. This is by far the provision most affected by this new code, with more than 12 different amendments, and affecting, we think, almost all aspects of the process. This I leave to your view if this has been done appropriately. There have been so many amendments that some of them are, we think, innovative, and some of them need some kind of clarification, because when we were discussing those, it was really not so clear what we wanted to achieve with those. So, and this is, I hope, a good opportunity to clarify a little bit those aspects, but also with the documents that you can understand where we are going. First big thing, and this I can tell you was an input coming from Emilio that I really struggled to understand how this would be implemented, but what is also true is that the reasoning behind was good, I really comply with that. The wording was really a very difficult exercise. So the main idea is that the FIFA judicial bodies will be able to increase the interest rate up to 18% from the date of the disciplinary committee. The idea behind as well is to avoid debtors from voluntarily avoiding or delaying the payments. So the way we are trying to do that is by making them not so interesting, the fact of delaying that process. Here is a graphic, and I think that is helpful because it also helped me out a lot when we were drafting the proposal to the FIFA Council. So the thing is, we have a decision of the Football Tribunal that is appealed to CAS, final and binding CAS award, and then what is the debtor doing? Back to the disciplinary committee, again hoping that it can avoid the payment, and it's from that moment on that the interest rate can be increased up to 80%, and it's up from that date that it will be enforced. So it doesn't have a retroactive effect, so it starts to count as from that date. Next change, or important change at least, is the one of persistent failure. We have the experience that the disciplinary committee imposes the registration ban until the debtor is paying, and 3 months later we have the creditor telling us that they persist not to pay. Well, the notion of persistent failure is not, shouldn't be like we have a decision and 3 months later, not even serving the first transfer ban, that you can lodge a claim for persistent failure. What does it entail? That they request disciplinary measures, that we have to open a disciplinary procedure, and in most of the cases that we have to close it, making angry again the creditor, and we know that they have to receive the money. So what we try to give with this new code is a definition of that, very simple one. Persistent failure, you can only request after the expiration of 3 complete transfer windows. Afterwards, you are entitled to request that persistent failure and to opt, well, to opt not, but that the debtor is imposed with more disciplinary measures apart from those of the transfer ban. Very interesting, I think, also for those of you who are on the other side, maybe there are no sides, but on the side of the debtors, is the provisional lifting of the transfer ban. It's quite common, but not to say quite often and usually, that debtors became aware of the debts during transfer windows. So, and also at the end of the transfer windows, which is quite interesting. So the process there is how to, when they do the payment, they come to us and say, I did the payment, please lift the ban because in 2 days I have a match and the transfer windows ends up in 2 days. Okay, so we have to start a process, and it's not that fast. Sometimes the creditors are really honest and say, okay, lift the ban, I will wait for the confirmation. So the idea here is, if the debtor is giving FIFA, reliable evidence that they have paid, the disciplinary committee might provisionally lift the ban until a confirmation is given by the creditor, without passing through the creditor before lifting the ban. But if the information is not accurate and precise, there will be severe sanctions against the debtor. What is reliable evidence? We put that, it's open, but we put that as a good example, is the SWIFT number, so that we know that the bank has processed the payment and it's ongoing. Bridge between the Football Tribunal and Disciplinary Committee. Again, a situation where we have the Football Tribunal imposing 3 windows, 3 transfer bans. Those elapse, what happens next? Can the club register players or not? Well, obviously the club will say yes, and strictly spoken, it's right. The club is right, because it serves already the sanction, and until another sanction is not imposed, they can register players. So what we tried is to fill that gap, providing the disciplinary committee the possibility in the frame of a claim of the creditor to give to decide to provisionally extend that sanction. That means that that 3-window transfer ban will expand until a final decision of the disciplinary committee has been taken. So we think that it's a good way of filling that gap. Enforcement of private settlement agreements, another thing that we think it's worrying or concerning both sides, debtors and creditors, is that they started procedure disciplinary, and then suddenly they want to reach a settlement agreement. Normally, as it has been done before, is that if you reach a settlement agreement, and here is the first graphic, that is a contract. You need to, again, go back to the football tribunal and start the process again. So what we have decided, or FIFA has decided here, is to cut that vicious circle and say, if within the disciplinary proceedings you reach a settlement agreement and someone breaches that settlement agreement, the disciplinary procedure will be reinstated from that moment, and it will be the disciplinary committee to decide on that dispute around the settlement agreement. So FIFA Football Tribunal to the disciplinary committee, settlement agreement back to the disciplinary committee, which I think, or we think, will ease a little bit the process, and also for the both parties, because sometimes they say, no, we don't want, or the creditor doesn't want to reach a settlement agreement because they don't want to go to the start again. So integrity experts, I'm still fine on time. Integrity experts, again, the purpose here is very simple. We want to increase our capacity to investigate, but not only to investigate, also to take better decisions with more precise information, more thorough investigations, or more specialized investigations. And this, again, we bring it from our experience at UEFA with the discipline and ethics inspectors, which are a great subject, a great figure of that legal framework that has provided plenty of success. We had the cases of Skenderbos, the Turkish saga. Some of you have watched a video I prepared, a Star Wars video, involving more than 6 cases of match fixing, what to say about doping and other issues, other sensitive issues. The figure, the role of the inspector at UEFA, at least from our side, was quite important, and we tried to transfer that to our own system. So they will be able to investigate possible offenses. The parties will be informed, so it's nothing hidden. So an integrity expert will be appointed, and then they can do whatever investigation step they want. Well, not they want, obviously, respecting fundamental rights. Written inquiries, engaging third parties, forensic, and also questioning individuals. So a circular will be released, and it will contain the conditions, the terms, the expenses that we will cover, as well as a tender process for the future integrity experts. We hope that it will come out in the next 2-3 weeks, and that we can already count with our new integrity experts in a way of 1 month and a half. So if you want to apply, well, of some of you or some people you know, if you want to apply for that, be attentive to the news that we will release shortly, and be our new integrity expert. So we move forward to the Code of Ethics. Here I will only focus on one topic, which I think is the most important one, is the sexual abuse, for which we, I would say, have invested all our efforts to protect better the victims and to specialize also better
In line with its continuous efforts to modernize and improve football's regulatory framework, FIFA recently approved key changes to its Code of Ethics in order to further improve the protection of football and its stakeholders against illegal, immoral, or unethical behavior. Indeed, experience has shown that victims of sexual abuse or harassment need greater protection in ethics proceedings. On that basis, various provisions of the Code have been amended, specifically to 1. clarify the status of the victims as party in the related proceedings, thus enabling them to be notified of the decision and to subsequently appeal it. 2. Extend the related prosecution period so that no sexual offence remains unpunished. And 3. Ensure worldwide application of any sanction imposed in relation to sexual offences. Further improvements have been included in this new edition of the Code, specifically to strengthen the accused's rights in ethics proceedings by enabling them to be defended by a pro bono counsel when they cannot be reached. Extend the scope of competence of the Ethics Committee to enable it to investigate and prosecute serious infringements that do not fall under its exclusive competence. Recognise substantial assistance provided by persons involved in ethics proceedings by offering them the possibility to enter into a plea agreement in specific situations. Provide greater transparency and clarity on some provisions of the Code, such as betting and gambling, as well as time limits, and reflect new entities and regulations in relation to the new FIFA Football Agent regulations. The new edition of the FIFA Code of Ethics has come into force on the 1st of February 2023 and can be accessed on the dedicated portal at legal.fifa.com. FIFA and its judicial bodies are confident that the changes adopted will enable them to continue providing their stakeholders with an optimal and efficient system to protect football and its integrity.
This is more or less what the changes are all about in this new edition of the Code of Ethics. And as I said before, I will only focus on the protection of the victims of sexual abuse because we think at this moment in time, this is, if not one of the most concerning issues that we have at the moment in football, and I would say also in sports organizations. So, first of all, say that our commitment is full. I think at least this is my view, it's undisputed that we are constantly, permanently and flawlessly fighting against this protection. And even though we had already cases before, but the case of Afghanistan, and Marta, the head of ethics, can tell you about, it was really something so cruel and so villain that it opened many eyes in terms of where we realize that if we are doing things, we have to do more things and better. If FIFA is not the most, at least it's at the same level as other sports organizations, or the best sport organization in terms of fighting these atrocities. So, as a way of example, we have been investigating, adjudicating a lot of cases, but like it's always in law, and we are all lawyers here, not always we are successful. And we regret not to be successful, but this is law. And we have to learn, or we already know, that law is difficult. And law is even more difficult in a situation where evidence is extraordinarily difficult to gather. And this is where we think that we should do our exercise, that we need to learn, be better, be more specialized, but we need to learn how to handle these kind of cases, how to investigate them, how to adjudicate them, and I would say also at all levels in sports, not only internally at FIFA, but also with regard to other judicial organs. Just to let you know, and it was also mentioned in the video, these are the changes, and you will see it gathers, we not completely, but we are really strongly moving forward in this sense, in the protection of victims. First, they are not subject, these offenses are not subject to limitation. It's the only offense in the Code of Ethics that is not subject to any time limits. Victims of sexual abuse will acquire the status of party once the decision of the adjudicatory chamber is rendered. That means they will have full access to the final report, to the evidence, to the decision, and they will have the right to appeal the case to CAS. Then the confederations and associations will have to notify immediately any decision with regards to sexual abuse so that we can trigger the process of extending the sanctions worldwide. FIFA will be able to agree, and this is important, with the MAs and the confederations whether to take over the competence, because sometimes, and we have also examples where we know, and the member association knows, that because of the sensitivity of the matter or because of the resources at place in that institution, that in the period of 3 months, as it was before, because we had to wait 3 months until we could get the competence, that in that period it wasn't possible to conduct investigations or to adjudicate this matter. So we can now agree with the member associations to take it over and to move forward with the investigation and the adjudication. And finally, I think this is also very important, just to keep out these individuals from football, is the fact that we now, as it is done also in doping, we can implement provisional sanctions on those individuals until the decision is taken, in the sense that the length of that sanction can always be expanded until the potential sanction that that individual could be served in the future. And as you know, sexual abuse has, as it's also very normal, the most severe disciplinary measures of the code. This is the QR of the FIFA reporting portal. I think it's important that you know that there is a reporting portal, that there is this direct link in case you have the chance to speak to victims or to whoever has information. Provide them that link, and it's anonymous, and we will 100% look into that claim. There is no claim we are not looking into. So any claim that comes through this portal, we will look into that. So just 2 more little secrets, and I will be over with this presentation. Granting of res judicata. This is very interesting because CAS and also the Swiss Federal Tribunal has decided that FIFA's decision, or decisions coming from the sport organizations, are not vested with the res judicata effect. So what are we doing? We are using our autonomy, our extraordinary independence, as stated by CAS, and we are giving that wording to the code so that FIFA judicial bodies should not deal with cases that have been previously subject to a final decision. Thank you, Miguel, for that input. And then proposals by the Secretariat, interesting as well. So don't be surprised when you get a proposal from us. It means that we take over the experience of the player status, of the Football Tribunal, where they are proposing the sanctions in cases that are straightforward, very important, only those offenses where a single judge can decide upon. And we, as the Secretariat, propose, if the parties agree, the proposal is final and binding. If they don't agree, we continue with the disciplinary process. Just to mention, we have an annex, something new as well, with the list of sanctions, so you can check and make your own calculations whether that proposal is okay or not. So that's it from my side. Again, the QR of the disciplinary code, also from the FIFA Code of Ethics, about the overview. Again, it's all the changes included, an explanation, the wording, and also what we would like to achieve with that new wording. So, thank you so much. Enjoy the day, enjoy the event. Enjoy El Clásico. Thank you.
Thank you very much, Carlos. You actually did great. I mean, every year you're improving. I mean, today, really fixed. Excellent. Do we have any questions for Carlos? If not, that means we have exactly 15-minute break. So see you back in 15 minutes. We still have one question? Yes, we have. Of course. No break.
Hello, I'm Dong-Ho Lim from the Korean FA. I have a question about sexual abuse cases. Sometimes there are victims that do not want to reveal their identity. So in those cases, sometimes they won't even want to identify the exact date of their the sexual harassment or any abuse. So in that case, would still FIFA or for us, would it be possible to still make this as a case and have disciplinary sanctions imposed upon them? So,
but the question is about the date.
For example, if there was a coach who, let's say a coach raped some parents of their students, so actually we had an incident that there were about 3 victims, but all of them did not want to reveal their identity. So we just we met the victims by ourselves, but we did not inform the accused person of the exact date and exact identity of the victims. But still, we imposed a sanction. We gave a lifetime ban on that coach, and actually currently the coach has brought this case in Korea. We go to the civil court to when the sanctioned person wants to nullify the case. So currently we are on we have a civil court case against this coach. So I was curious if this could happen.
I would only answer in the extent of what I know about FIFA. I don't know anything about Korean civil courts still. Who knows? But the thing is, it's a very tricky question. Can you impose sanctions with victims without revealing their identity? It's a yes. We have the Afghan case where we have anonymous victims and they provided a statement, but it's not about the statement of the anonymity of the victims. What is important, I think, it's the way they give that testimony. The way, the elements around the testimony that makes reliable that those statements. No? And this is more or less what the analysis will be done from our chambers, but also from CAS, as we saw in the Jambar decision, and that is key. It's also true that, again, those cases, the evidence is quite limited, and then the only persons that can give evidence are persons that are scared. Sometimes for cultural reasons, they are not even supported, and even the opposite. So it makes the whole thing very, very, very difficult. And this is the reason why I know I'm being very FIFA at this moment, because I'm just going to other ways. But this is what I think is so important in this case, is that we all have to learn how to deal with the cases. It's, we cannot re-victimize the victim. We have to know how many times a victim has to state their case, because then it's quite interesting to see, or surprising, that the argument is that they are inconsistent. Well, if they have to live again and again the same situation, then the statement becomes a little bit fragile, because it's suffering by them. So my answer, at least in the framework of sports organization, is a yes. But obviously the accused party has also rights, and those rights need to be protected by the legal framework. How we are doing that is that, for instance, the victim can address to the chamber, the accused can ask questions to the victim without being that direct communication, and all those kind of ways is the manner that that statement can be valid before our organs. I don't know the civil courts in South Korea. Thank you.
Thank you.
Thank you.
One last question, please, here in the front.
Well, good morning, or good afternoon, rather. I have a question, a specific question. In a Latin American country, we've had 6 cases that have been presented to the public ministry to go through the legal way, but the case is stuck. It's not moving forward. So my question would be, what happens when the ordinary legal path does not move forward? We know that these women were sexually harassed and abused by the coach of a club, so what do we do? I answer in Spanish. Okay, so labor disputes, are not my thing, but in the specific case of sexual abuse, the proceeding is independent from anything else. Things that may happen before a tribunal is independent from things that may happen at an MA. And for several reasons, because the way the case is treated is different, because the burden of proof is different. I think that your question moves along the lines of, if no one does anything, how do I do anything about it? Well, in that case, we have the reporting system. You can contact to FIFA and we will review the case. It is true, though, that we do our analysis, if we consider that the MA has done things the right way from a technical perspective, there's not much we can do, because of course we need to give this space to the MAs. We need to take care of them, but they need to take care of us. So if things have not been done the proper way, then we can open some space for FIFA's intervention. However, we need to keep in mind that FIFA would be intervening in a process where the MA is requested to justify their actions to see if they have acted in the right way. I must admit, though, and this is part of what we are working on at FIFA, is that we are lacking some things. And this is something that is at the table. I'm not talking about who has the competence on a case or not. I'm talking about what happens when someone does something, but we think some other thing should have been done. And this is not really very specific at the moment. We haven't really worked on that much. Maybe in your case, the result is not what FIFA would have liked to achieve, but if theoretically the case, has had all rights have been respected and the proceedings have been followed, there's not much FIFA can do. Maybe, however, over the next 3 years, FIFA comes up with a new regulation that can shed some light to that situation. That's what I can say. I wouldn't really like to go into that direction with questions because I feel, very touched by this topic. But of course, you have freedom to ask whatever you consider. I see someone else took the mic at the bottom of the room. Carlos, related to the previous question, I think that there was a proposal some time ago so that FIFA and the Ethics Committee would have just the only competence with sexual abuse cases. Many times what happens is that MAs may have problems to carry on the investigations. However, from what I've seen in your presentation, this is not the case. And I think that, I would like to hear, I'm not sure if I understood it right, but I would like to hear about the agreement of the FIFA Ethics Committee and the agreement that they may have with the MA. I don't think it's that easy that they can make that agreement, so I would like to understand how that fits into the reform of the Code of Ethics. Thank you so much. Your question is very relevant, as always. What I would like to say is that what we are trying to implement, and we need to keep in mind that there were several proposals and some of them were not accepted. But what we are trying to implement does not depend on me or Emilio or our team. And we cannot decide what will be decided at the FIFA Council, right? We bring everything and then, you get what you get. And you must be thankful for that. So regarding that proposal of taking the competence of all those cases, Well, I think that if we look at how the Code of Ethics works, and considering that the Code of Ethics was already changed in 2018 in order to give more autonomy and independence to the MAs, if we go back now and we tell them, no, now we take care of those cases, maybe we're sending the wrong message because we're telling them maybe they are not doing the right thing. And there are many MAs who are doing the right thing, and that many MAs want to take it seriously and handle these cases. So maybe also being somehow selfish so that FIFA doesn't end up handling 800 cases of sexual harassment. Our position is there's a case of sexual abuse, as it may happen in some African countries, for example. Then we see that maybe the case is stuck, and then we contact the MA and we tell them, we are here. Do you want us to take competence over the case? Yes? Okay, we'll do it. No? Okay, but know that we are here. And you have 3 months to comply with all the steps. And if you don't do what's required, we will jump into it. And I think that's a good agreement between MAs and confederations and FIFA, because we can reach an understanding if we act this way without attacking anyone, without intervening too much, but also keeping the opportunity open of intervening after 3 months. So how can we reach this agreement? Maybe you are in a better position than I am, to explain this, because actually, this comes from the experience we've had when you were the president of the investigatory chamber at FIFA. And as you know, there were several conversations between the MAs and the Confederation, and that's how we got to a point where we decided on this agreement. There was a lot of steps taken, and so far it's been quite successful. Not always, but in general, things have worked out pretty well. Thank you so much. Thank you, Carlos.
Also for those who are following us on the live streaming. See you in 15 minutes. Thank you very much. Mexico City with us. For some, it's already late in the evening, but I hope that you're still watching us. Otherwise, as I told you before, everything is recorded and will be on FIFA.com. So I'm very glad to present you our next speaker to end day one. We have here with us, already ready on the stage, Miguel Lietard, FIFA Director of Litigations, who will give you this overview about CAS in football in the year 2022. Thank you very much, and Miguel, the floor is all yours.
Muchas gracias.
Thank you, Maya. I will start in Spanish and say two things. I was going to say two. I will say three in the end. First and foremost, I would like to thank our Mexican hosts from the Mexican Football Association for welcoming us in their town and in the CONCACAF territory, which is a territory that I belong to as well. Thank you, Maya and Emilia, for counting on me for the floor once again. And then thirdly, I would like to clarify something. If Carlos was nervous about a match that's coming up, that's because he is rooting for the wrong team.
To English for the only presentation in the floor which requires a break beforehand and a break after it so that you can prepare for it and then recover for it afterwards. As always, I'm going to be presenting, or start by presenting, the main figures from last year, even though many of them you've already seen in the CAS in Football Annual Report. So just very quickly, appeals against CAS, against FIFA decisions, in 2022, 360. So a little bit down from the 492 of 2021, but still substantial. Last year, we were, however, maintained in quite a larger number of procedures, so over 31% of the cases, the parties did not accept to withdrawals from the different proceedings. Of those 111 cases in which FIFA was actually a party to, you can see each of the departments from which all of the appeals came. As is usual, the vast majority of the decisions appealed were from the Football Tribunal, and to that you can add the 249 cases in which FIFA was not included as a party. As for the awards received last year, we received 61 awards on the merits, some awards dating as far back as 2018, a couple from 2019. Of course, the more recent ones are from the last couple of years. And if you look at the outcome of the awards, we're more or less along the same lines as in previous years, with 80% of the appeals being either dismissed or partially upheld, as always, partially upheld, usually based on issues of proportionality with respect to the financial elements involved in each of the cases. One of the more interesting points is that we had a few more cases, instead of upholding the appeal necessarily, referring the cases back to the Football Tribunal or to the relevant body disciplinary committee as well for a new decision in those situations. So having presented these numbers, I go to the most relevant things. I've selected, as always, two cases to present. There's been a lot of awards which were quite interesting. It's not always easy to choose these, but a couple of them could stand out for different reasons. I hope that they'll be useful. Otherwise, in the annual report, you have a summary of all of the jurisprudence that was received in the past year as well. I start with this first case involving Mohamed Keita, just to give you a little bit of background. Player and club sign an employment contract in January 2020, valid for 2.5 years. November 2020, the player puts the club in default because the club had not paid outstanding salaries as well as the signing bonus that it was due according to the contract. Now, this is not a typo, but after having been put in default, the club actually produces an agreement that was allegedly signed between the parties on 10 September 2020. So it had been signed 2 months before the player's default notice. That agreement basically foresaw the amicable termination of the contract, and in that agreement the player acknowledged that he did not have any outstanding monies owed to him by the club itself. In FIFA, proceedings start and the player contests the authenticity of the termination agreement and terminates the contract with just cause, then files the claim to the DRC for breach of contract, and the club in response argues that the claim should be dismissed because they had a valid termination agreement and therefore there had been just cause. Now, the DRC, within the framework of those proceedings, was provided with the original copies of the termination agreement, also another document that had been signed by the player, and in the absence of any expertise, it basically did a layman's analysis of the signature and concluded that those two signatures were the players. And as a result, it found that the termination agreement was valid and that the claim had to be dismissed. The player appealed to CAS, so this is where CAS jumps in, and two issues are basically raised with respect to the termination agreement. The first one was, did the player actually sign that contract? The player claimed that, first of all, he had not signed it, and in any case, he signed it under duress from the club. The arbitrator, however, observed several things. First of all, that the player had not managed to have the agreement assessed by an expert, even though he had plenty of time to do so. And on the other hand, that the player had not demonstrated that he had been threatened or otherwise coerced when signing the agreement. On the first point, the expert report, if you'll recall, at last year's floor, we presented another case in which precisely the expertise with respect to the authenticity of signatures was deemed to be quite relevant. Here, interesting takeaway is the sole arbitrator's position that in the absence of any expert report, especially having had quite some time to obtain one, it could not be concluded that it was not the player's signature on that termination agreement. Second issue, having determined that the termination agreement was signed by the player, at least to the arbitrator's satisfaction, and that the player had not been under duress, could that termination agreement be considered binding on the player himself? And there, the sole arbitrator, in the absence of any specific views in the FIFA regulations, turned to Swiss law and found the three general requirements. First of all, the intentions of both parties to withdraw from the contract, in other words, to terminate the contract, has to be unequivocally established. Secondly, the reciprocal claims waived have to be of an equal value or an approximate equal value. And thirdly, the employee must benefit from a period of reflection when it's the employer who proposes the mutual termination of the contract. So the sole arbitrator turned to Swiss law, all decisions of the Swiss Federal Tribunal, which you see referenced on screen. Now, applying this to the case at hand, the sole arbitrator could not appreciate it really whether the player had been given that proper time of reflection because and the club had not credibly and seriously set forth any benefit that the player would have obtained in exchange for the concessions that were made by him. It's important to recall that at that time, the player was owed potentially 21 months in wages. Those are the amounts that he had originally claimed to the FIFA Dispute Resolution Chamber. And when terminating the agreement, the club did not make any concessions that would be approximately equivalent to the amounts that were owed to the player. So, having taken into account that the player had not been given a proper period of reflection and that the counterbalance between what was offered by the club and what the player had agreed to was not of an equivalent nature, the arbitrator found that the agreement in this respect was ineffective. And again, in general, a termination agreement which doesn't meet those conditions is not binding on the parties, and therefore the agreement should be disregarded. So the sole arbitrator, when analyzing the player's appeal, the player's claim within the de novo scope of review, determined that because the agreement was ineffective, could not be held against the player, the parties had to go and be put in the position that they would have been if that agreement would never have been signed. As a result of that, the player's appeal was upheld, and and the club was ordered to pay to the player the outstanding amounts owed, as well as compensation for breach of contract by the club. I turn to the second case. Just a little disclaimer, this award is technically from mid-January 2023, but it was probably already ready to be notified in 2022, so I include it in this mix also because it has several issues that we find quite interesting as well. A bit of background here too. The club and the coach enter an employment contract, which was then replaced or extended depending on how you want to consider it. One provision in the contract stipulates that the parties agree to resolve all disputes either amicably and otherwise agree on the jurisdiction of the Court of Arbitration of the Croatian Football Federation in this case. After COVID-19, the pandemic, competitions were suspended, and the club decided to unilaterally reduce the salaries of its employees. The coach told the club that he, of course, did not agree with that reduction. It was unilateral, had not been negotiated, and therefore, after the coach's complaint, the club terminated the coach's contract. After that, the coach filed a claim before the Player Status Committee, and at the FIFA level, the club contested the jurisdiction of the PSC, arguing that the contract precisely provided for the jurisdiction of the Croatian Court of Arbitration. And as to the substance, the club said that it had the right to reduce or to modify the contractual conditions because of the circumstances at that time, mainly COVID, and therefore that it was right to eventually terminate the contract unilaterally under those circumstances. The PSC judge entertained the claim, partially accepted it, found insofar as the jurisdiction of the Player Status Committee was concerned that because the clause at stake referred to the tribunal but did not mention the exclusive jurisdiction of the tribunal, the PSC was therefore competent to decide on this particular claim. The club appeals to CAS, and several issues arise. Proceedings are carried out normally at the beginning. Appeal is filed, parties exchange written submissions, a hearing is held in September 2021, and then a few weeks after the hearing is held, the CAS court office informs the parties that the arbitrator that had been appointed by the appellant wished to disclose certain information, and basically the disclosure was that he was an arbitrator of the Croatian Court of Arbitration, of the Arbitration Tribunal, of the Croatian Football Federation. As a result of this disclosure, FIFA challenged the appointment of the arbitrator, and the ICAS Challenge Commission agreed with FIFA's challenge and removed that particular arbitrator from the proceedings, arguing mainly that the doubts that were raised by FIFA as to the independence of this arbitrator in a proceeding in which the validity and the independence of the Croatian Football Federation's arbitration tribunal was at stake created legitimate doubts as to the own arbitrator's independence and impartiality. So the challenge was accepted, the arbitrator was removed, the appellant, Dinamo Zagreb, was offered or requested to nominate a new arbitrator, and then the case moved forward, a second hearing was held, and then the panel issued its award. Again, very recently. The issues that were analyzed by the panel, and by the second panel, to put it one way, first of all was, did the PSC have jurisdiction to entertain the coach's claim initially? Now, based strictly on the applicable regulations, it was no, because at least because the panel did not agree with the legal reasoning behind the PSC's decision to assume jurisdiction. I'll recall that that reasoning was because the jurisdiction clause in the contract did not foresee the exclusive jurisdiction of the Croatian Federation's arbitration tribunal, and because that clause was not exclusive, the PSC would have been competent. That was the reasoning of the PSC. Panel here disagreed with the PSC's reasoning because, first of all, the regulations don't refer to the need for an exclusive jurisdiction clause. Secondly, because following CAS jurisprudence, an employment dispute of an international dimension can be settled by an organ other than the DRC as long as there's a clear reference in the employment contract, which was the case here. There was a clear reference to the Court of Arbitration of the Croatian Football Federations, and also reverting to Swiss law and to the Private International Law Act. The panel observed that Swiss law establishes that unless otherwise agree, the parties otherwise agree, the choice of forum is in an event exclusive. Therefore, there was no need to refer to the exclusive jurisdiction of the tribunal when, in this case, Swiss law, which applies additionally, foresees that it's already exclusive in itself. Just as a quick reminder, when analyzing also the independence of a national arbitration tribunal or one under the federation, of course, the requirements were originally foreseen in Circular 1010, and continue to be so, but of course the regulations have evolved to add additional conditions or to specify in a clearer manner the conditions that are required in employment disputes between coaches and clubs of an international dimension, of course. So, bearing that in mind, bearing the rules applicable to the procedural rules applicable to the dispute in itself, so the former edition of the RSDP, the panel had to analyze whether the Court of Arbitration of the Croatian Football Federation complied with the minimum criteria set out by FIFA. First issue, again, just for clarity, this was a majority decision, was that the burden of proof the majority of the panel found was on the appellant in this case, so on the party which claims that the National Arbitration Tribunal complies with the requirements and should be competent. In other words, with the party contesting FIFA's jurisdiction. Then, as to the minimum criteria, again, the majority of the panel found that it applied, that Circular 1010 applies also to disputes involving coaches, so not just to disputes involving players. Following this, the panel focused on the principle of parity, which implies that in a scenario where arbitrators are to be selected from a predetermined list, every interested group must be able to exercise equal influence on the composition of the list of arbitrators. So interested groups, we're talking about players, coaches, clubs, etc. And therefore the panel had to analyze how the members of the Court of Arbitration of the Croatian Federation were appointed. In this case, all members were appointed by the Executive Committee of the Federation, which is fine. Many members of NDRCs, etc., are also appointed by the executive bodies of Federation. However, the panel noted that in the Croatian Football Federation, the Executive Committee had already a number of members who were club representatives at that time, whereas the rest were representatives of other individual direct members of the Federation, but none of the representatives or the members of the executive committees were either representatives of players, so former players, or of the coaches, with the exception at that time of the president of that federation. So therefore, there was no influence from players or coaches or their unions or associations in the composition of the list of arbitrators of the Croatian, of the arbitration tribunal at the Croatian Federation. So, again, the conclusion by majority was that the principle of parity had not been met. The minimum criteria from the circular had not been met, and therefore the PSC had correctly assumed jurisdiction over the dispute in itself. So those are basically the two cases that I wanted to present. Luckily enough, I've managed to make it in time and to recover part of the time that was lost. So I just open this for questions. Before I do so, as Emilio said, it's also important to keep the gratitude for the end. I've already thanked our hosts and the organization. I just want to give one last thanks to my team in litigation, who fortunately enough is here. This presentation is just a small snapshot of the work that is done by this department and by the rest of the FIFA Legal and Compliance Division, so thank you to my team. And of course, happy to hear any questions.
Thank you very much, Miguel. Do we have any questions for Miguel? No? No one?
Everyone's hungry.
Looks like everyone is hungry, so thank you very much, Miguel. Also, thank you very much to all the speakers that we had today. Thank you to our interpreters. Thank you to all of you being here. Thank you. And we look forward to see you tomorrow for day 2 that will focus on specific aspects of CAS. Same place, same time. Enjoy your lunch. Buenos días, buenas tardes, buenas noches. Thank you.